much. We're going to have people throughout the country tuning in and out during the course of this symposium. And I want to give a special word of thanks to Professor Mark Sundahl, who has been a pioneer for us in this law school and frankly, throughout the nation with regard to forming our Global Space Law Center. We have a philosophy here at our law school that we need to do the same thing that Wayne Gretzky used to do. When Wayne Gretzky was once asked what made him a Hall of Fame hockey player, he once said, "I just learned how to skate where the puck was going, not just where the puck is." And that's exactly what Mark has done. He has served as a role model for our faculty and staff and students by skating where the puck is going. By forming the Global Space Law Center, he has attracted an amazing number of students to our law school who, frankly, before hearing about the Global Space Law Center, didn't have an interest in this area, and now are spending a lot of their time, if not most of their time, learning about the orbital economy. And I can't tell you how excited our students are because of what Professor Sundahl has done. I should also tell you, by the way, that although it's a coincidence, today is Mark Sundahl's birthday. So I hope each of the panelists sometime during today will wish him a happy birthday. I don't think he did this on purpose, but I thought at least you should know that it is his birthday today. I also want to say to you that we couldn't be more honored to have such a distinguished group of panelists throughout the day, including an astronaut. And I've looked at the biographies of each of our panelists, and the fact that you're spending time with us is a great honor to us, and we truly, truly appreciate it. All I can say is that there is no more exciting area of the law today than the area of law that we'll be talking about. So I want to thank all of you, and especially again, Professor Mark Sundahl, who often says to us, the sky is no longer the limit, and you are proof of that. Professor Sundahl, back to you.
Thank you so much, Dean Fisher, for those inspiring words. And we're going to try to figure out where that puck is going. And I have to say that we at the Global Space Law Center, and especially me, appreciate your support. It makes it so much easier for us all to achieve our goals, to progress beyond the limit of the sky. So let me welcome everyone, all the attendees. We have a large group that have come from across the country and in some instances from around the world. We have students joining us. We have practitioners, practicing lawyers. We have entrepreneurs, executives from space businesses. We have government officials, policy pundits from NGOs, and even some academics. And so we have a wide range of stakeholders that are joining us today. And it's just another indication about how hot the issue of space law and policy has become. And today is not only my birthday, that's less important, but today is International Human Spaceflight Day, also known as Yuri Day, in commemoration of the April 12th, 1961 flight of Yuri Gagarin, who was the first human to pierce the heavens. We have, fortunately, as the dean mentioned, an astronaut among us today who will be introduced to you in due course. But I want to welcome everyone, and I hope that this is well worth your while. We have a dynamic program planned. And whenever I put these symposia together, I try to create the anti-conference. There will be no reading of papers. There will instead be a dynamic conversation and an actively moderated series of panels, 5 of them altogether, each of them which will last 45 minutes, and each of which will be followed by a 5-minute Q&A in which we will curate and select a couple of questions from the audience to pose to our panelists. So 5 45-minute panels, Q&A after each one. For those of you who are here to earn CLE credits, welcome to you. And just be aware that at the beginning of each Q&A session, there will be a poll launched, a true or false answer that will flash on your screen and be there for a minute or so. And you have to answer it in order for us to confirm your presence so that you can earn the CLE. Okay, now why are we talking about the new orbital economy. Why was that topic selected? There's so many things going on in space, and I have to say that I've been guilty of focusing on the moon, and the Artemis program has been on everyone's lips. The Artemis program being, of course, NASA's program to return to the moon and create a permanent human presence on the moon. And we'll be doing this in coordination with many international partners and private companies. So you can imagine all of the legal issues that are arising now as we embark on this mission en masse to build a human presence on the moon. We want to do so in a manner that avoids conflict and interference. And there are many working on the issues that present themselves, including, for example, natural resource extraction. Fascinating issues there, but we will not be talking about those issues today. They are fascinating, but let us not be mesmerized by the moon. There are also extraordinary transformations taking place in low Earth orbit, and that's why the topic was selected, so that the appropriate attention is given to that very interesting and important topic as well. Why do we call it the new orbital economy? That's quite a statement. It indicates that something has changed, and things have changed drastically and will continue to change. And what are the indications of this change? Well, maybe the most striking number is the increase, the inflation of satellites in orbit, of spacecraft in orbit. Just a few years ago, if you asked those that track functional satellites, you would hear that there are approximately 4,000 operating satellites in orbit. Within a couple of years, that has doubled, and that's going to continue to increase. How high? It's hard to say, and that's going to be one of the topics that I posed to our panelists in the first panel. But the number of objects could go as high as 50,000, 60,000. What's the limit? It's not clear, but it's certainly creating congestion in low Earth orbit. And so the issue of space traffic management is a critical issue that we're going to look at. What else is new in space? Well, because of the advent of reusable rockets, in part, which is cut by multiple orders of magnitude the cost of achieving orbit, certain businesses which may not have been feasible, financially sustainable in the past, are now back on the drawing board and are taking steps forward. And what are some of these new space applications or segments of the space industry? Well, there'll be on-orbit refueling of satellites, on-orbit repair of satellites, private space stations, and human spaceflight in orbit, that is orbital space tourism. There are other applications that are coming down the pike, such as potential solar energy collection in orbit, which will be beamed down to Earth through microwaves and then distributed. Unlimited renewable energy. So these are some of the transformations that have taken place, and it's the result, largely, of the advent of reusable rockets, which has made it so much cheaper to achieve orbit. But it's also the result of a long-standing strategy that was adopted by NASA to eventually hand over low Earth orbit to private industry, so that NASA's resources can be redirected and applied in the most efficient way to do those things that private companies cannot do, such as exploring the oceans of the moons of Jupiter. But we're coming very close now to achieving this goal of handing off low Earth orbit to private industry. Now, one indication of that and maybe one of the final steps of that transition will be the decommissioning of the International Space Station, which has been a tremendous success and example of international cooperation, but all things have an end to their lifespan, and the plan at the moment is to decommission it in 2031. Will there be another International Space Station? No. Instead, the platforms in orbit for scientific research and perhaps eventually manufacturing will be provided by private industry. We're going to have private space stations, such as the Orbital Reef that's been proposed. But there are many projects for that. NASA will still be active, of course, in orbit, but will be purchasing a ride from SpaceX to send its scientists to a space station. And that space station will be a private space station and not the publicly funded one that we have now. So these are some of the very exciting things that are going on in orbit. It is a transformation. It has really stolen the attention of Silicon Valley venture capitalists. And so capital is pouring into the industry, making the entrepreneurs' visions reality. And so it's a very exciting time. We are gathered here today to discuss the many issues that arise from this new set of affairs. And so I mentioned we're going to have 5 panels. Indeed, we will. The first one will be moderated by yours truly, and it will deal with space traffic management. The second panel deals with orbital human spaceflight. We have really no regulations governing the safety of orbital spaceflight. We do for suborbital, but not for orbital. So we're going to talk about what work needs to be done on that front, private space stations and human spaceflight. That panel will be moderated by Stephen Robeson, who is an attorney at McDonald Hopkins here in Cleveland and is also a former student of mine and currently also serves as co-general counsel for the Space Generation Advisory Council. So thank you, Stephen, for moderating the second panel. The third will be about rendezvous and proximity operations and docking. And this captures the on-orbit refueling and repair segment of the industry that I had mentioned earlier, and also the docking of one spacecraft to another. And of course, all of that is going to require great strides in standardization and interoperability. So we're going to talk about that segment of the economy that's emerging. Then we're going to get to the fourth, and I will be moderating that third one. The fourth panel will be moderated by another former student of mine and a former student of Professor Frans van der Donk, who is joining us in the second panel, Scott Perry. And Scott Perry is a member of the International Institute of Space Law, as well as the Moon Village Association. So Scott will be taking over the duties for the fourth panel, and that will deal with orbital debris, environmental issues, kinetic anti-satellite tests, and the decommissioning of satellites. How do we dispose of them at the end of their life? Then finally, the fifth panel, which I will return to moderate, deals with liability issues and dispute resolution. And so, of course, as business increases and as the number of actors in orbit increases and the traffic increases, there are going to be disputes and there are going to be accidents. And we need to talk about the best way to resolve those disputes for the space industry. So that is the plan. We are so far on target. We're at 1:15. So let me wrap up this introduction by addressing our panelists and let them know that the format of this symposium, again, is one of dynamic discussion. So the moderators will be posing questions, but I want the panelists also to feel a sense of freedom to follow their thoughts in the spirit of a brainstorm, but also at the same time, be sensitive to your other panelists. As I mentioned, there'll be no speeches, but there will be spirited dialogue, I hope. So with that, I'm going to ask the first panelists for the first panel to please switch on their cameras and join me here in the Zoom room. Very good. Well, welcome to all my panelists here. We have 4 panelists. The first one, Gary Dresden from the Department of Commerce, Office of Space Commerce. And I have to say that that office is becoming increasingly more important. So thank you for coming today, Gary. We have Jennifer Manor of EchoStar USA. So someone with the industry perspective will be joining us as well. Dr. Antonino Salmeri, who is joining us, I believe, from Rome, would be my guess. This is largely a collection of American experts, but I have salted a few international speakers as well. We will be joined by Antonino, Frans van der Donk from the Netherlands in the second panel, and then Laura Zielinski from Mexico City in the final panel about dispute resolution. So welcome, Dr. Salmeri of the Lunar Policy Platform, I have to mention. And then finally, he's probably familiar to most of you. If you know people in the space industry, you will know the name of Brian Whedon, so of the Secure World Foundation. And I'm very happy to have Brian here to join the conversation. So that's it. The 5 of us are here to take on the questions of space traffic management. As I mentioned in my opening remarks, we have orbital congestion, or so it seems. When you double the number of active satellites and foresee the creation of the expansion to unheard of numbers due to the advent of mega constellations, such as Starlink, which provides high-speed internet service from low Earth orbit, very low Earth orbit. But there will be other mega constellations, such as OneWeb. And I received word recently, and maybe some of the panelists can comment on this, that China is also interested in launching their own mega constellation. Of course, it's not only the United States. So the question arises, how much is too much? And do we really have congestion? Space is a big place. So let's kick this off. I think you all understand the general issue. The question now is, what do we do about it? And the first thing that can be done to make space a safer place is to be aware of the space, of the situation that you're in. Be aware of the traffic and the presence and direction and location of the orbit of other satellites around you, or which may be around you. And so this space traffic management function, which has been historically overseen by the military, by the Air Force, has recently been transferred to the civilian office of the Office of Space Commerce in the Department of Commerce. So I would, although I won't be calling out any panelists on each occasion to answer a question, in this case, I would like to ask Gary Dresden to let us know how that transition is coming and what the future holds for us.
Absolutely. So first, let me just take a step back and thank you, Professor Sundahl, for organizing all of us, and wish you a happy birthday. And also, I want to go back to Dean Fisher's Wayne Gretzky quote, because there's one thing to follow the puck, but then space traffic management and what the Office of Space Commerce is doing is watching the hockey players and trying to keep them from hitting each other. So it sounds like a really daunting task, and luckily for us, satellite operators are a lot friendlier than hockey players, and their goal is to not bump into each other. So space situational awareness is a little different there. But it's hard to believe that it was only 5 years ago the directive came down for the Office of Space Commerce to take on this new role. And so much has changed since then. Professor Sundahl, you mentioned the increase in the number of satellites. I think since 5 years ago, we probably have 3 times as many. And that's not even to mention how much more orbital debris there is. So the good news is that the Office of Space Commerce is making significant progress and reaching key milestones. So I want to break that down a little bit for everyone so we just know what's going on in the Office of Space Commerce. So some of you may have heard previously that it was referred to as something called the Open Architecture Data Repository, but it's been rebranded because of its increased scope to the Traffic Coordination System for Space, or TRACS. And there's really three components within TRACS that you can expect to see. The first is TRACS Oasis. That's a data lake for commercial SSA data that's going to provide everyone awareness of the information and what's going on. And then there's TRACS Skyline, and that's actually the services that the Office of Space Commerce will include in its basic space safety flight awareness work. It'll include things like conjunction alerts, warnings, other services, and actually I would encourage everyone today to go into the Office of Space Commerce website, where there is a recording where we went through a bunch of the different types of services that we anticipate including in TRACS Skyline, and the opportunity for more conversations with industry and the public about fine-tuning that list. The last component is called TRACS Horizon. And so I think that's a really special one too, because the Office of Space Commerce is really doing more than just transitioning current services. We're looking forward and looking to the future. And that will be a research and development proving ground for future products and services where people can come in, test their products, improve, create advanced services, et cetera. So it's really a broad and ambitious goal with TRACS that will provide services, encourage commercial leadership, go through the research and development work, and promote standards and best practices for space situational awareness. So you asked about what have we done so far. I'll just hit a couple of milestones that we hit. So last September, there was a memorandum of understanding or agreement signed between the Commerce Department and Department of Defense. And I think that's really important in this process because it really laid the groundwork for that transition portion. And we've been meeting with the Department of Defense every 2 weeks, discussing it, working on annexes, developing ways to transition data. So that was a big milestone. It continues throughout the life cycle, but it's going well. The second one I briefly touched on, it's the interaction with industry. So in January, we issued the request for information. And what's really special about the Office of Space Commerce is that it's really looking to partner together with industry as it's creating these services. So we're asking industry for their input about what's going on, what they can do, how they can be a part of TRACS. And then the last is a future milestone, and that's in the third quarter of 2024. With the funding that came to create TRACS, there was also a deadline. So by next year, by the third quarter of next year, we can expect to have initial capability ready for public use. It'll have some basic services and be a beta for groups of users, but it will provide meaningful traffic safety coordination to the public. So you can expect a lot of progress in the next year and a half and a lot of public-facing interaction from the Office of Space Commerce for each step as we develop this.
Interesting. Is there, to follow up on that, is this service something that only government is able to provide through the abilities and capabilities of government, or are private companies also providing space situation awareness and STM services?
Yeah, so I think that's a great question. So private companies are absolutely providing space situational awareness and space traffic coordination services. In fact, the TRACS program hopes to utilize a lot of what's already out there within its program. So what I mentioned before when I said this TRACS Skyline, that's going to incorporate a lot of what's already available through commercial entities. Now, what the Office of Space Commerce thinks is that there are certain capabilities, certain services that just have to be provided from a safety perspective, right? And so that's why the Office of Space Commerce is becoming the preeminent expert in what is space safety in this space traffic management sphere. And our challenge, and I think as we're going through all of this industry feedback, public comments, is to strike the right balance between making sure that space is safe, but also not hampering those great companies that are already doing space situational awareness, and making sure that we're encouraging the domestic market there.
Excellent. Thank you very much. I want to open up the floor for reactions to that or thoughts about the congestion of mega constellations in general.
So, Mark, if I could jump in here, I want to commend Commerce and what they've been doing on this, because this really is new. And Mark, you mentioned that a lot of people see this. What the DoD's been doing the last several years is STM. Well, I think the DoD itself has gone to great, like I say, they don't do STM. They just kind of provide information. But that service and what the products the DoD has been done was never created with space safety in mind. It was, they're doing that for national security purposes for other reasons. And there was a policy decision made 2010 in the wake of the Iridium Cosmos collision that the DoD would expand that service to provide that for everybody for free for a kind of whole host of national interest reasons. But again, their systems, their data, their whole process was never designed with this in mind. And so, the Department of Commerce is the first entity in this government that has really thought about this deeply in terms of what should this look like? What are the end user requirements? And that's a pretty daunting task, in part because we're still debating, after 20 years, what is space traffic management, right? That is still a huge discussion in our community. You're going to get, 10 different answers on this. And also I just want to flag just sort of how long it's taken us to get to this point. The 2010 National Space Policy sort of started this process. In fact, at the result of that, they created, the Obama administration created an interagency working group that started formally working on what is space traffic management. But by the end of the Obama administration, they didn't come to an actual policy decision. They created some definitions, they did a lot of groundwork. They didn't come to an actual decision. That didn't happen until the SPD3 process that happened near the Trump administration, which we mentioned came out in 2018. But even that policy decision didn't have any money attached to it, because that's, of course, the role of Congress. So it wasn't until the end of 2020 that Congress actually gave Commerce the authority to do the civil SSA and gave them the money to do that. And they were actually able to start working. So this has been a 15-year process to get to this point in the United States, and yet still quite a lot of work to get done, because I'll point out that Congress, while Congress authorized and funded the civil SSA mission, they have not given Commerce expanded authority for on-orbit activities or any kind of regulatory thing. That's still a little bit up in the air. And so, a lot of us think that is sort of the management function, and that is still, I think, a TBD question. Now, hopefully soon we're going to hear an update from the administration on mission authorization, which has also been ongoing for quite a long time, that might help address that. But I think it's interesting to see kind of both how fast how much has been done in the last couple of years that Commerce has been tasked with this, but also kind of step back and see how long of a running policy process this has been. Again, just the United States. Of course, Europe has got its own process going on.
Maybe I can build upon that. Thanks, Brian. And happy birthday, Mark. I wanted to start with that. It's no coincidence that you have been born in the International Day of Space Flights. That's a great honor, and definitely something that tells that your destiny in space law was written in the stars. So congratulations and happy birthday, my friend. So I wanted to build upon what Brian just said, right? Because what we just discussed is SSA, right? Space Situational Awareness. And it is certainly the starting point, and it took a long way to go. But I will tell you that, especially from a European perspective, the next step that we're all really looking to discuss is what are we going to do with these capabilities? Now we do have the ability to track and monitor, and I am grateful to what the Commerce is doing in order to make sure that the commercial interest is specifically taken into account, because those are the primary players that will come into play, especially in the near future. But the question becomes, if one angle has already been addressed, which is like looking at the commercial players, the other angle is looking at the international dimension of this issue, right? Because space traffic management cannot be managed like separately, individually, like we would do with air traffic control. Each nation is responsible for its air traffic control because it's in a sovereign airspace and in a very delimited portion. Space is not like that. We have to be mindful that there cannot be different STM systems. There should be a broader governance system for STM, or at least agreed rules of engagement for how do we give precedence from one satellite to another. If it remains, because we are lucky, in the realm of domestic policy, because it's 2 American companies, for instance, or 2 European operators, then could be relatively easier. But when we have international actors getting or almost bumping into each other, then that's where we want to have rules of engagement that we all can agree upon to avoid conflict, to avoid tensions, and to avoid, obviously, accidents. Now, we have managed so far, and so far so good, apart from few cases like one that Brian mentioned. But as Mark said, we have doubled the number of satellites in just 4 years, right? And in the next 4, we'll probably double again, if not triple. So the time to start working on these rules of engagement is now. And the question is, how do we want these rules to look like? So I'll pause here, but just add one final thing. Mark previously mentioned that the moon is monopolizing discussion. As someone working in this field, in the lunar policy platform, I cannot agree more. Today, we're here to talk about orbit, and it's important that we do that also because most of the money, let's face it, so far, it's still in orbit. But let's also be mindful that whatever we're going to do with STM will be also a very relevant analogy for the moon, right? And it may not be a problem of the next 5 years, but in time, we're also going to have to figure that out. So let's try to be mindful of the precedents that we set in discussing space traffic management, not only for Earth, but also for future exploration of celestial bodies.
So, and maybe I can weigh in. I agree with my fellow panelists say, but most importantly, happy birthday to you, Mark. But I think this international dynamic is critical. It's something that I was actually, so I'm a real fan, Gary, of what you're doing at the Office of Space Commerce. I wish you were funded earlier and for more things. As a US company, I can say that. And I hope that funding continues at adequate measures, which I know is a difficult thing when you're subject to political whims. But anyway, hopefully the industry can help you with that and the government. But more importantly, one of my big disappointments was during the Trump administration when the Artemis Accords came out, and there was no mention of space traffic management. There was no mention of looking at something more, space sustainability more generally. I thought that would have been a great start, because I do think we need an organization, international organization. I know how hard this is, that is charged with that. And I will tell you, I'm on the spectrum management side as well. I just came from Geneva last week at the International Telecommunications Union, and this was a issue at our Plenipotentiary conference last year. It's going to be an issue at our World Radio Conference. Countries want to take some action here, and they want leadership. And I agree fully with Antonio that it's got to be international in nature. Otherwise, you're not going to get the buy-in. When we're dealing with spectrum, scarce resource, we sit there with all the countries of the world, ones we're friends with and ones we don't have such great relationships. And unfortunately, some of the ones we don't have such great relationships have very well-funded space programs. So I fully agree. I think we have to capture the momentum to try and bring this internationally. And, I'm not sure what the right body is. I think an important thing is whatever body it is, it has to have the commercial industry involved with so much of space being driven. And Mark, you forgot a very important company, eSpace, which is planning to deploy 300,000 satellites, which would put SpaceX to shame. So just to add to the number.
Yeah. Great issues that have been raised. Thank you. This discussion's is really catching fire now. I want to turn to Gary and just follow up on the question of international consultation. To what degree are you working with our international partners? I think people would be interested to know, because I'm sure you are.
Right. So the intent for let me break this down, because the Office of Space Commerce does a lot of things, right? There's a regulatory program overseeing commercial remote sensing. There's an advocacy branch. There's the Space Situational Awareness Program. And then there's also the part that's working with the US government and trying to develop international relations as well related to space policies more generally. So it's a big bucket, and different parts of that bucket have different relationships internationally, right? So from the regulatory approach, we're often talking with sister agencies in different countries that are regulating commercial remote sensing to make sure that the approaches are coordinated, reasonable, not inconsistent with each other. But when it comes to space traffic management, I think that the biggest level of coordination is going to come with data sharing and also standards development for, what are we doing and what are the best practices. So the Space Situational Awareness Program tracks, that first portion tracks OASIS. That's supposed to be available for international use too. We're not trying to limit it. So we are trying to take in information that we have, that other US companies have, that they want to include, and that other foreign or international bodies have. So we want to create a collective space that people can use. But then when it comes to best practices, we also want to coordinate internationally, talk to other, a lot of it starts with what the companies are doing, right? Just a week ago or 2 weeks ago, the best practices for space traffic were released by the Space Safety Coalition. So there's so much leadership going on by the private industry that is going to help us cross international bounds too and start the conversation.
Interesting. Now you mentioned the Space Safety Coalition. Dr. Salmeri made this distinction between space situational awareness and rules of engagement. It's one thing to be aware of the environment so that you can take the necessary actions to avoid interference, and that is very important. I don't want to minimize that. But then there could be other positive rules set in place to help minimize interference, such as keeping a required distance from one another, perhaps certain technological components required to allow for sensing, satellites sensing one another. Where are these rules of engagement being developed? Is the Space Safety Coalition the leader in that area right now? And I'd kind of open it to anyone on the panel. What thoughts about that?
So this is one of the pressing challenges, right? The answer is everywhere. Space Policy Directive 3 stated that the US would base its future space traffic management framework and rules on industry developed standards. And that actually same language is present in the Space Traffic Management Directive issued by the European Union last year. There are a whole bunch of different industry best practices, standards, sort of things that have been put out. You have the Space Safety Coalition, you have a set that was put out through AIAA, including SpaceX and Iridium and OneWeb last year. You have Confers, which has been working on standards, best practices related to satellite servicing and rendezvous proximity operations. You have the Space Sustainability Rating that's been going on, multiple other groups of entities that are working on things. So one of the real challenges, something that we at Secure World are starting to look at, is how do we kind of look across all of these and start to do some sort of meta-analysis or some sort of coalescing of all of these different proposals into something that could be a baseline. And there's that's really hard to do because there's a set of best practices related to debris mitigation. There's a set of best practices related to avoiding collisions. There's a set of best practices related to post-mission disposal. And do we start with all of that? Do we pick one of those as one of the others? That's part of the real challenge here.
Dr. Salmeri,
no worries. I just wanted to chime in because I think it was Gary mentioning first the importance of standards and capabilities that we have, right? And I want to emphasize here the importance of interoperability, which is becoming a buzzword also in the lunar environment and here especially. I'm glad to see that we have Chair in this room because I think like last year we were together in a panel in Luxembourg discussing automated collision avoidance systems and SSA and the importance of having the same data, right? Of making sure that we see the same thing, because sometimes we disagree whether or not there's going to be a collision and what is the risk of a collision and all sorts of those technological, let's say, challenges that we don't have the answer today in this very legal discussion, but we have to figure it out, because if we cannot even agree on what are the dangers, on what is the situation objectively, then we have a problem taking a decision, and we have a real risk if the decision is taken automatically by automated systems based on data that differ. So I think the part of data sharing and standards interoperable systems development is a key one. And here we need to look at some technical organizations that can really do this also convening work in putting together all the parties, as Brian said, and making sure that we have a baseline, not only for the rules of engagement that I mentioned before, but also for this technological capabilities that will drive them.
So Mark, I just want to build on this because I think the elephant in the room is that we don't know what the actual, well, at least I don't, but maybe these gentlemen are smarter than me. Is we don't know what space is or how to define it. You know, do you look at someone was, you know, we've been fighting internally in the satellite industry, you know, how do you grapple with this? And I always think the first thing is, you know, what's the size? When we looked at the geostationary orbit, it was a pretty easy calculation, right? It's 360 degrees, you know, you can go plus and minus a certain amount. So you could figure out what station keeping, you know, but here we don't even have an agreement. You know, there's a lot of people who say, well, you shouldn't start space traffic, you know, shouldn't worry about it below 400 kilometers, which I think is crazy. Others say 200. My view is that everything should be included. I don't care if you're a university. You know, but I think the first thing we have to do is define, at some point, we've got to define space. I did a search the other day just to see, you know, how many methodologies there are. And there actually are surprisingly few, because I think it's such a big problem. But I don't think we can we can design some rules. Yes, do you need propulsion? Do you need this? But, you know, does it have to be deorbited? Yes, but really in terms of spacing and safety, and I think the question of how much is too much. I don't think any of us, I mean, I hear 300,000, I go, that's too much, but maybe it's very reasonable, or maybe, you know, maybe 60 is, maybe Iridium's too much with 66 satellites, you know, we don't know. And then you've also got the issue of equitable use of the space resource, right? That's a treaty obligation that almost every country, if not every country in the world has. So how do you ensure that? But I don't think you get to any of that until you can measure what space is.
Very good point. And 300,000 seems like an extraordinary and impossible number of satellites, but it's a matter of understanding how big space is. And I did invite a well-known astrophysicist to join us. He wasn't able to, but the remarks that have been made coming out of those fields of expertise have been quite apocalyptic. And it's hard to know how urgent it is, but we're going to revisit that in the final panel today when we talk about debris. Let's move to the.
Sorry, Mark, just one quick follow-up on that.
Please,
you know, I think a lot of people had concerns about, you know, when Starlink first proposed they were going to do 3,000 satellites as a constellation. They've actually been doing a fantastic job of managing it, in part because they've developed an automated system for doing conjunction assessment that has done thousands of automated maneuvers. Honestly, a lot of people in the technical field thought that was impossible when they first announced it, and they're now doing it. Now, the question is, how does that scale? How does that work when you've got multiple constellations of thousands that are interacting and maybe have different criteria, or can you scale it up to tens of thousands? All of those are unknowns. But, you know, I just want to emphasize this point of, we honestly don't know what the real level of risk is here, and where that threshold is, where it's okay to all of a sudden, oh my gosh, we have a real problem on our hands. And that's part of why this is so difficult to get a handle on.
Absolutely. The question, there was an issue raised by Antonino that we don't always all have the same information. And so I want to kind of turn the conversation in that direction and ask, where does the original information come from? Is it entirely through you know, scientific sensors? Or do we rely, and to what extent, on international law and the registration convention? I've been doing some work with Antonino on proposing alternative methods of information sharing as we return to the moon. And the case for a new and alternative method is very clear in that case, because the registration convention was not designed for lunar activity and is not particularly well suited. It is designed for orbital activity, but there's still, it would seem to me, flaws with the convention as it stands, most notably that it doesn't require immediate registration. So there will be a lag between when something is put in orbit and when the world is informed of it. So I'm going to just throw that out to the group. Where do we stand with the requirements, international requirements to share information?
Mark, can I just raise one issue before the others go? Just that there's also a number of countries that aren't members of the UN Register of Objects Launched into Space that, I can tell you the commercial space industry at least files through. So I'll turn it over to others who know more about it. But I did want to flag that there are, I can think of probably 5 to 10 countries that are, who have ITU filings through the ITU, for networks that aren't members. So I would be interested too in hearing from these guys what that means.
I can start with the registration convention. Mark, you and I have been working on this for like the past 2 or 3 years now, even though more in the context of lunar activities, right? But I think mutatis mutandis, we can make similar considerations. I would say, like you said, the registration convention was designed for the orbital environment, but it was designed as a TBCM measure, right? For transparency and confidence building. It's mostly to make sure that there are no dangerous satellites up there or no weapons and things like that. It was really not designed to serve as a repository for then information useful for safety purposes. So I would say that unfortunately the registration convention is not helpful to that extent, to be a basis for information that then drive SSA and STM. It's going to be there. It's extremely important for, like I said, for TBCM, for transparency, but I don't think it can give us an answer. And that's why it's so important to develop additional capabilities that can complement the registration convention and make sure that then we get the information we need to ensure the safety. And I'm very curious to hear from Gary, especially, I would say, because you ask, where do we get the information, right? Where is it based from? There are certainly capabilities that we have. Do we need to expand them? And then eventually, how does that goes into play with the international dimension of it?
Yeah, just to add on to that, I fully agree that the convention was not designed in this operational sense, at least what it's asking for, right? So for example, it sort of says, provide these products, in a relatively timely manner, sort of a thing, right? It doesn't even say, we're talking in the practice has been months, if not in some cases, year or more after launch before states have provided some stuff. And it also doesn't, says just sort of initial orbit sort of thing, right? There's nothing in there about, you have to provide, ephemeris, right? The really detailed things you need to do some of this stuff. So yeah, I agree with you. The registration convention as is probably not suitable for kind of a basis for the kind of data that we need. But I think it is useful in terms of, more towards the ownership and the liability and jurisdiction and control, because that's a whole other question we haven't really talked about now is, there are 2 objects that are conjuncting in space, and who owns what and who's potentially liable, and then who do you contact? I think the registration convention is more useful in terms of that sense, although obviously there's a whole range of other challenges, for example, with all the debris objects, the vast majority of which are not registered or in anyone's national registry. And so who owns them? Who do you ask permission to go remove them? That's a huge unanswered question when it comes to things like debris removal and some other aspects.
Yep, yeah, absolutely. And you foreshadowed our 5th panel on liability. We will be talking about that. So I'll remember that comment when it comes up. But Gary, you've been put on the spot here. What are your thoughts about gathering information?
Yeah, absolutely. I agree with my esteemed panelists that the registry is not built to create this safety traffic system. That's not the information it provides. But the question of where the information comes from is a good one. So at least for tracks, the information is going to come from a lot of different places. So there's SSA capabilities on the ground where people are looking up into space and trying to track objects there. That type of information can be put into tracks. There's operator information themselves. So while we can't require all operators to provide the information, terms of service for use of tracks could include certain requirements to provide certain ephemeral data. So that's important information that will go into tracks. Other information is from other operators in space. So again, Office of Space Commerce regulates commercial remote sensing. A lot of the land remote sensing operations that are taking imagery of the Earth are adding capabilities to also be able to do space situational awareness, so they can feed into the track system. So it's almost like saying, I guess, we have a lot of little eyes all over, and we're putting all that together. And the hard work for the Office of Space Commerce is to figure out a way to filter all of those into one database that makes one source. And like Antonio says, have clear terms so that when people are getting these conjunctions from tracks or conjunction warnings from tracks, they know what it means. and they know how to react, and that other, other international operators are also getting those warnings, they agree to the general principles and the data underlying those warnings.
Thank you. Thank you, Gary. And I want to add one thing on the relevance of the registration convention. I just posted in the chat a link to the report of the working group on the status and applications of the treaties within the legal subcommittee of the UN Committee on the Peaceful Use of Outer Space, because they've been working recently on recommendations to enhance registration practices specifically for the purpose of registering mega constellations. And in the document that I sent, which is the draft report of the working group, which will need to be approved by the main committee in June, there are 3 recommendations that are meant, let's say, to add additional information that could be helpful for that. And there is also a new project started by the UK Space Agency and the UN Office for Outer Space Affairs called the Registration Project, which is also meant to interview different stakeholders to gather their current registration practices and again propose more operational solutions. So even though, as Brian also confirmed, it was not designed for this purpose, and I don't think the registration convention will never serve the purpose of being an operational tool. There are also efforts to try and make it a little bit more useful, also to solve the questions that Brian pointed before, right? Ownership, but also I would say jurisdiction and control, and then liability as well.
Thank you for that, and thank you for sharing that data. I don't know if our attendees outside of the panelists have access to the chat room and the documents shared, but that can't be helped. But I do want to make attendees aware that we do have written materials on the Symposium website, which I encourage you to go and read, and includes articles, one written by Dr. Salmeri and another by Professor van der Donk, among other things. So I wanted to mention that. Is there, outside of the United Nations, an international group initiative to address these issues of space traffic management in the form of, like, the Moon Village Association has their global expert group on sustainable lunar activities, which gathers stakeholders from around the world? There was a similar effort at the Hague Working Group for the governance of space resource activity. Is there something akin to that happening for space traffic management that anyone is aware of? It sounds like, yeah,
there
go
is
ahead.
for sustainability. So the International Telecommunications Union is responsible for spectrum and also orbits. And at last year's plenipotentiary, there was a decision that the World Radio Conference, the radio communication sector, will start looking at the sustainability of space, and that includes things like equitable access. I'd be shocked, and I don't think the ITU is the right group to do the spectrum traffic management. Brian's smiling; he fully agrees with me. But in terms of access and safe operations and things like that, we do have certain rules in place at the ITU for geostationary orbit satellites today, and so that's a body, but I can't think of any other body that's out there that's kind of a fringe, something you don't think about as a regular.
No, I agree. I'm not sure the ITU is good suited to be handling this, and I'm not sure nothing comes to mind that directly. I know UN COPUOS has been looking at this issue, and they worked on for up until 2018 the long-term sustainability practices, which touch on some of the issues related to space traffic management, but I wouldn't say that they're explicitly space traffic management or really kind of operational. They're very high level recommendations. There have been some discussions there on space traffic management, both in the scientific and technical working group, and as Antonino pointed out, in the legal working group. But there's not anything organized that's going on there that I'm aware of. And as far as I know, there's not any other group that is sort of overarching looking at everything, which is partly why, like I said, we at Secure World are starting to think about this issue of how do you kind of get your hands around all these different best practices. And that's sort of, I think, part of the challenge here, right? Is that there isn't anybody looking at this. And we made a comment earlier about relation to the air traffic regime. In that regime, you have ICAO, which is creating these international standards that are then implemented at the national administration level. In the US, that's the FAA, and every country has one, and they're sort of the regulatory body in each country that implements them. We don't have that. And of course, there have been many discussions about should there be an ICAO for space or something along those lines that I think are still very much unsettled. Another topic that I've been exploring recently, we're going to talk about at our Summit for Space Sustainability in New York in June, is this question of maybe there's some internet governance frameworks lessons we can learn here. So, for example, in the internet world, they have a set of what are called multi-stakeholder organizations, meaning that they're controlled by not just governments or not just the private sector, but their boards are a mix of governments and industry and civil society. Things like ICANN, which does internet name assignment, and the Internet Engineering Task Force that does a lot of the standards work. We're trying to look, maybe there's some lessons there that we could apply to some of these things on space in terms of creating international standards or come with broader frameworks, but that's still very exploratory at the moment, right? None of this stuff is going to be directly copyable from air or maritime or the internet to space, but maybe there's some things we can learn.
Great. Those are great ideas. And of course, there's plenty of work to be done. We only have a few more minutes in this panel,
Mark.
and I wanted to spend a couple of minutes on a very different topic, but one that's also been created by mega constellations. Antonino, did you want to put a final?
Just want to really quickly chime in on what Brian said. Couldn't agree more on the importance of multi-stakeholder groups. And that's something similar that we're looking in the lunar environment now. The lunar policy platform that I have the pleasure of lead is exactly trying to experiment with that approach. And I think it would be extremely beneficial for STM. And on that note, I just posted in the chat another link. Sorry, I'm going to be your link guy for this panel, which is the result of a study conducted by the International Institute of Space Law, the IAA, and IAF on STM. So they've been really putting together an interesting group of experts, which release a comprehensive report, and they have a space traffic management committee at the IAF. So that's another group that could be useful to keep in mind in this kind of discussions.
Excellent. Yes, and as I mentioned before, the MVA GEGSLA is another model that could be followed for creating this multi-stakeholder international advisory group. But we have 3 minutes, but I wanted to throw this to our panel. What can we do for our poor astronomers who are suffering from these mega constellations, which are clouding the sky and interfering with their very important work? They are also part of the space industry, but these mega constellations have caused quite a bit of complaints. Can anything be done about that?
So, I mean, you could do quiet. I mean, so yes, you've got the idea. You could do a quiet zone. I don't know how that would work, but I would point out there is work being done on this. The idea of a radiodynamic zone where they're looking at this. Brian probably knows where this is better than I do in terms of things, but I could say I came from a meeting with the National Science Foundation literally last week, and they still have very heavy concerns over this. But I don't think there is a single answer today.
Yeah, I'll just add that this year, UN Copia Scientific and Technical had a working group on dark and quiet skies that had some good discussions on this. Unfortunately, I think it got tied up in some broader geopolitics, and I'm not sure if it'll continue. I don't know if they agreed on continuing it again next year because of just lack of agreement on a broader thing. Antonino, I don't know if you know any better on that or not, but it is being discussed. Going from discussions to actual actions, I think, is still uncertain.
Yeah, following up on Brian, there has been discussion, like you said, it's been dragged into geopolitics, but it was agreed to do a symposium next year at the Scientific and Technical Subcommittee. So there will be an opportunity for discussion, not very extensive, couple of probably 3 hours in the plenary session, but a start, as you said. And in terms of what we can do, I think the first thing to do would be discussing these issues, right? When the whole Starlink problem happened for the first time, it seems like nobody was aware that this could have happened, and probably doing some consultation a little bit before could have been helpful. So I think being more proactive in trying to imagine this kind of issues, and also on behalf of the astronomy community, that they should be more outspoken in terms of the dangers they see so that we can discuss before these things happen. And then there are ways to solve it. I think SpaceX has been incredibly proactive in that. We can learn from that and repeat it. And I see Gary is probably chiming in on that.
Yeah, I'll be quick because I know we're low on time, but I think that I agree 100% with what Antonio is saying about this needs careful thought. And there's a lot of Band-Aid solutions that can help in the interim that, Starlink is using things like sun visors, darkened materials, but really there needs to be a larger look. And one of the reasons that hasn't happened is because of the licensing process, where when these mega constellations that are often doing communications work are licensed, they don't have to go through what's the National Environmental Policy Act, where the actual impacts of the human environment are considered. And that dates back to a long time. There was a government accountability report that was released last year that recommended that the FCC relook at the reasons why it hasn't been considering the impacts to the environment. And I think the FCC is committed to at some point relooking at that. But I think that's a critical missed opportunity. And I think you're absolutely right when you say it kind of snuck up on people because we've been avoiding that question in a lot of the licensing decisions. So it's past time to take it head on.
Interesting. And one of our panelists, not from this panel, but someone who is still watching, has sent a great thought, and that's Karen Chenoweth, who you are likely familiar with. But Karen just texted in our chat room that maybe the solution is to take astronomy off planet. When we have 300,000 satellites, it seems extraordinarily difficult to pierce that veil. And it may come a time where we already have, of course, telescopes in orbit and beyond. Maybe that will be the ultimate solution. But time will tell. Unless there are any urgent last-minute comments on this issue, I have a question from our attendees that I am going to recite. And those of you that are seeking CLE credit, you'll see that a question just appeared on the screen. So please go ahead and answer it. Here we go. Okay, this question comes from Chris Van Eyck, who is concerned that while private industry has been very forthcoming in sharing information about their constellations, naming SpaceX here, that other countries have not been as forthcoming. Is there anything that we can do to compel countries to be more forthcoming with information about their space activities?
So unfortunately, no, I'll get it started. Although I am not yet convinced that it is anything nefarious, right? Even some of the companies, right, aside from their initial filings, have been very vague about the details they didn't have to disclose in the ITU or the FC or the ITU filings, the FCC applications. A lot of this is pretty. I think perhaps she's probably alluding to China's plans for their GW constellation, which has been a little bit in flux, right? There were 2 smaller constellations that some of the satellites are already on orbit that appear now have kind of been combined together into a much bigger project that is theoretically pitching about 13,000 satellites that is being managed in a at least a pseudo commercial way. That is still very much in flux, and they haven't really done anything yet. So I'm not sure it's necessarily an issue of hiding things versus they still don't have details to publicly report. So that is coming. There's also, as we mentioned, the eSpace, or I think the final name was Cinnamon or something like that, which is the 300,000 that was filed under Rwanda, which is also sort of very nebulous at the moment. So honestly, there's nothing you can do to force sovereign countries to do anything, other than sort of maybe, I don't know, encourage a little more information. But I'm not sure it's out of the ordinary in terms of the lack of information at this point.
I will touch up on this because I fully agree with what Brian said. And thank you, Chris, for the question. It's great to have you also in this event following the discussion. I've been personally promoting with Mark a possible solution to this, which is what we already have in the Outer Space Treaty, right? Which is Article 11, which says the states agree to share information about the nature, conduct, location, and results of their space activities. And that has been a very underutilized provision of the OST, to say the least, perhaps one of the most underutilized. It's formulated in an interesting way, right? It doesn't say that states shall share information, but it says that they agree to, and it is done to the greater extent practical and feasible, if I recall correctly, the text of the treaty. But it is it is a mechanism that we need to use more. And again, referring back to the working group on the status and applications of the treaty in the legal subcommittee, they agreed to take this as the next item for discussion next year in COPUOS. So I would say there's going to be progress to make sure that sovereign nations do better in being transparent and sharing information. Again, this is a key principle that we do already have for the moon in the Artemis Accords, and hopefully the same could be applied, building upon Article 11 also in the orbital environment.
And with that, I will exercise the prerogative of the chair here and adjourn this first panel. I want to thank our panelists very much. Gary, Brian, Jennifer, Antonino, you have made for a very happy birthday for me so far. I enjoyed the conversation, and again, very much appreciate the time. So at this point, I will ask you, the four of you, to turn off your cameras, and you will disappear. Thank you, Antonino. And I'll ask the panelists for the second panel to please switch on their cameras and join the Zoom room. And I'm going to turn the moderating duties over now to Stephen Robeson, who I mentioned before is an attorney at McDonnell Hopkins and the co-general counsel of the Space Generation Advisory Council. So Stephen, welcome, and I will leave it to you to introduce your panelists.
Yes, sir. Thank you, Mark. And like everybody else, happy birthday to you. So welcome to the second panel. We're doing orbital human spaceflight and private space station. So as Mark noted, although private flights to the ISS have already commenced, the US has virtually no regulations in place governing the operation of private space stations and human-rated spacecraft in orbit. This panel will explore the needs for such regulations and what form they might take. So with that, today we have Dr. George Neal from the Commercial Space Technologies LLC, Jessica Noble from NanoRacks LLC, Marcia Smith from SpacePolicyOnline.com, Gabriel Sweeney from NASA, and then Professor Dr. Franz Bonderdunk from University of Nebraska-Lincoln. Cognizant of our time, I'm just going to jump into the first one. I'm going to ask that Marcia Smith field this question. So suborbital human spaceflight has a few safety regulations, such as requiring that the cabin atmosphere sustain human life. Orbital human spaceflight has no safety regulations. Do we need new regulations in order to ensure passenger safety and non-interference with the orbital activity of others? Are new regulations needed to satisfy US international obligations to authorize and continually supervise under Article 6 of the OST?
Well, thank you very much for inviting me to join you today. And I didn't realize it was Mark's birthday, and it is, of course, the birthday of human spaceflight, so this is very appropriate. And I actually would like to congratulate you on bringing up this topic because it is very timely. Not only is it Cosmonautics Day, Yuri's Night, International Day of Human Spaceflight, whatever it is, but we do already have private astronaut flights into orbit. And the first commercial space station module is probably just 2 years away when Axiom launches up to the ISS. And so the clock really is ticking. It's been ticking. And I think that there's a lot of work to be done. It takes a long time, I think, even for the community to come to some, I would say a consensus, but at least some sort of understanding as to what kind of regulations would help them. And then you have to go through the whole government process, which is very time consuming. I was struck last week when the RAND Corporation came out with this report on whether or not they thought the learning period should be extended or not. That report was requested in 2015 in the Commercial Space Launch Competitiveness Act. So as long as it takes the government to do something, you know, and it takes the private sector a long time to do things as well. So the clock is ticking, ticking, commercial space is accelerating. And I certainly think that the questions that you presented to us all need to be answered. They're very complex questions, you know, and I congratulate you on sort of bringing them all together. And I doubt that any of us have answers to them. But I certainly think that the community and the government really need to sharpen their focus on this, which is going to be extremely difficult in the current political environment. As hard as it was to get things done in 2015, Washington is only becoming more partisan. So I think there's going to be a challenge in even getting anything done with the current issue of whether or not to extend the learning period. Getting anything through Congress is going to be a challenge. this year, and next year's even worse because it's an election year. So, you know, I would look forward to the conversation about this, but I certainly don't think that I'm in a position to say whether we need new regulations. I think, you know, some sort of voluntary standards might suffice. I think that those are the issues that the community and the government need to explore.
And Stephen, if I could weigh in, great comments, Marcia. If I were to answer the question, I would say we don't necessarily need new regulations, but I think we should be considering whether we need to update our regulatory framework. And let me tell you why. Obviously, space is important for national security, for technological leadership, for international competitiveness, as an inspiration for students who are going to become our future aerospace workforce. We also count on space for our everyday activities, for communication, navigation, financial transactions, weather forecasts, growing our food, and even for a lot of our entertainment. And recently, our dependence on space has continued to grow. For example, in the last 8 years, the number of FAA licensed launches has increased by a factor of 10, so an order of magnitude. And since July 2021, more than twice as many private citizens have been to space as have NASA and international partner astronauts. 46 private citizens versus 16 governments. We now have 14 FAA licensed spaceports in the US, with another dozen waiting in the wings. And I think there's a broad consensus among financial experts that the size of the global space economy, which is currently estimated to be over $400 billion per year, is likely to exceed $1 trillion per year in just the next 10 to 20 years. Unfortunately, in spite of all that, I think a very strong case can be made that as part of the FAA, the Office of Commercial Space Transportation has frequently not received the needed time and attention from senior leadership, ability to directly communicate with stakeholders, the resources it needs to successfully carry out their mission, or advocacy and support for resolving key issues in a timely fashion. So as a result, I think the time has come for us to formally recognize commercial space transportation as an independent mode of transportation. And I think you could do that very easily by taking the Office of Commercial Space Transportation out from under the FAA and putting it back at the Department of Transportation, which is where it was originally established by President Reagan back in 1984. I think such a step would go a long way towards maintaining a light touch regulatory framework that will ensure public safety and treaty compliance, while still allowing for innovation and advanced technologies and new ways of doing business.
So I have a couple thoughts on that.
I saw you on mute. I was gonna kick it over to you.
Yeah. I mean, and I certainly don't disagree with anything George and Marcia have said so far. I do think it's important to kind of dig down into the actual specific legal and policy issues we're talking about, right? George and Marcia have talked about sort of how big this is and how quickly it's changing, and that sort of points to needing to pay attention and needing to properly resource it, which seems right. But I think sort of those of us involved in space law and policy need to ask the more specific questions about which rules need to be answered now, for example, in the future, and how do we answer those? The reason I say this is because, you know, some of your prompt questions and the discussion questions, a lot of them are about human safety, for example. And I think that was part of the question you initially asked, Marcia. And I would submit, this is just Gabriel talking now, not necessarily on behalf of NASA, although it's not really our concern. I would submit, for example, that the Outer Space Treaty and sort of traditional space law doesn't care so much about human safety. And I'm not sure that we, the US government, need to worry about human safety for that reason. There are lots of reasons to care about human safety, right? Like you might want to protect your citizens. You might want to make sure that, you know, contracts and disclaimers and all that kind of stuff are appropriately followed and whatever. But I don't see like the need to protect human safety or how we protect human safety or what level of risk we impose on private spaceflight participants as an issue that's going to be sort of, let's say, needed to be handled internationally or through the Outer Space Treaty or something like that. That's something that government, I feel pretty confident that governments can decide to either do or not do, right? And not do could be let people take risks. That's a possibility, right? There's different reasons for that. Now, there are questions that really need to be answered by governments. One has to do with liability, like what would the liability regimes be for commercial stations and for commercial human spaceflight? Those are sort of different things, but what about liability incidents that happen? That affects the entire space community, not just those risk takers who are willing to be involved. So that's one. I also think there's some questions that are a little bit more fundamental to just the business models of CLDs, for example. Some of those have to do with things like jurisdiction and control, and those are important because space lawyers care about those things, but they're also really important for how those companies operate and for what customers they can get, whether they really need to just focus on, for example, US-based customers, or whether they can get customers from around the world, that sort of stuff. So I'm curious what Jessica has to say, because I think what we really need to do is hear from these companies that are engaged in this stuff. And we need to know from them, like, what levels of certainty do you need to make this even business viable, right? And then we, the government, will sort of manage the other stuff. But we do need to know, like, what are the implications on the business side? Because as best we can tell, looking from the government side, there's still a lot of unanswered questions on the market share, on what the business plan is, all that kind of stuff. And these law and policy questions are going to affect the success of these activities as business entities.
Jessica, you wanna jump in?
Yeah, and thanks for that segue, Gabriel. And before I jump into that, again, I need to also wish Mark a happy birthday. Sorry, you're just going to be getting this for the rest of the afternoon, but what a great way to be spending your birthday, just talking about space law. That's I can't think of a better way to celebrate. Well, but to Gabriel's point, and I think to put a fine point on the initial question regarding regulating human safety for commercial space stations or any of these operations on orbit, I do think that we're not yet at a point where we should be regulating it. I think that we're still in the very early stages, and one of the helpful factors right now, especially with the companies that do have contracts with NASA, either Axiom for their module that is going to be going to the ISS, or to the companies that have taken part in the commercial destinations free flyer program, is that we're still working hand in hand with NASA and learning from them on these human safety standards. So I think that that's something to take into consideration right now, is that we're working with a US government entity that has been doing this for the past 20 years on orbit. So I think that we're nascent right now in this, and regulating human safety for commercial space stations. I think we should probably be looking at a similar path to what we've taken with space flight participant safety, rather sort of the wait and see approach that we've taken so far. But I think that Gabriel's point as to some of the more pressing questions regarding what is the regulatory framework that is going to support the business case for these companies, mine and others that are looking to launch their commercial space stations in the next few years. I think that something that we should be taking a look at is this question of mission authorization and what that framework should look like to support in space activity, commercial in space activities. And another area that I think might be good for conversation, I'll be interested to see other folks' ideas on this, is looking at the export control regime and how that is going to apply to commercial activities on commercial space stations, both in the design and build phase for these stations, as well as the experience of the customers, if we're calling them astronauts or spaceflight participants, however we decide to, whatever terminology we decide to use for these folks, how that is going to apply to their time and their access while they are on these commercial space stations.
Thank you. Dr. Franz, do you have anything to add?
Well, it's obviously difficult following four great minds to add something, but you will excuse me that as a law professor and an international contributor to this panel, I'll be a bit more stern about regulation than probably the other four are. I would basically answer that question with yes, even though I recognize the many elements, and I certainly agree with George that we should start with, or I'm not a US citizen, so you should start with pointing out who should actually have that authority and how it works. But I do think at the end of the day, there needs to be regulation. And I also agree with Gabriel that it should focus primarily on these broader issues, like liability, including also, I would say, at some point, business opportunities. I mean, for the time being, let's be clear about this. The suborbital flights are just the suborbital hops. There's no real transportation yet. That is kind of the next stage in some of these projects. Some of them talk about flying New York, Tokyo in 1.5 hours instead of 12 in the not too far away future. Then, of course, there's the truly orbital flight where we're going to space stations. I don't have a crystal ball. I don't know how quick that will happen. But as Marcia pointed out, there's always a long lead time. So I think we should start developing that now. And there are a couple of more reasons for that. The last part of the question talks about the international obligations, and Article 6 of the Outer Space Treaty obviously is very sort of open-ended. It doesn't require any specific level of regulation. But given on the one hand that the US has taken its task of regulating non-crewed space flights, non-crewed launches pretty seriously with a quite detailed framework, I think it is, if not the right thing to do, morally speaking, ethically speaking, politically speaking, at least also the wisest thing to do to start developing that now. So far, all the developments in this context are obviously taking place in the United States. Even Richard Branson, who is obviously a Brit, has moved his operation to the US. And what is going on is basically a US operation. So the US can, in that sense, set the standards. And if they don't set standards that appeal to others, then there might be at some point a divergence there. I recall, for example, that in Brazil, which is trying to develop itself into at least a regional space power, if not a global space power, they have recently basically copied and pasted a lot of the regulations on space launches, because they do see that there is a very detailed and thorough effort there. So I would certainly make the case for regulation. I would certainly say that if Article 6 doesn't outright require regulation to the level that might have been developed currently in non-crewed spaceflight, I would certainly recommend that to be taken. And I do agree it should take place with a broader approach than just the safety of human spaceflight. As a European, I'm always reminded that in the United States there's a slightly more willingness to accept people taking their own risk. In Europe, we sometimes think we must protect people against too rash decisions which may endanger themselves. But there's a reason why all these activities are focusing in the US. I am not too afraid, by the way, that in starting to develop legislation or regulation right now, that the interests of the business will totally be forgotten. It's clearly a dual mandate of the FAA to not only take care of the public aspects of commercial spaceflight, but also to promote the interest of the private sector. I think that so far they have done a great job in doing so. But I would really recommend starting to think about doing these things right now, rather than just wait for the first space station to go up.
I think with that, then it kind of goes into the next part. So with the idea of the Article 6 obligations in mind, so what would the regulations of orbital human spaceflight actually look like? Can we simply extend the existing suborbital human spaceflight requirements to orbital flight with like the necessary amendments to the law? Or how is the orbital experience different than the suborbital? Should greater medical certification be required for passengers due to the rigors of the actual orbital flight? So I think moving on to the next point is with how would we actually implement that, or what would the regulation look like?
I would suggest, if I may take the lead here, to maybe start with that for obvious reasons, but at the same time think much more comprehensively about it. In a sense, we've been lucky that all the suborbital hops that so far have taken place could be regulated still by the FAA, because FAA obviously has only authority over launch and re-entry, but as soon as the launch ends, you're almost back in the re-entry phase, and even if there's maybe some phase in between, it's just short. But when we start to talk about orbital spaceflight, human spaceflight, and space stations, there will be people out there for much longer than just a few hours. And not everybody is as decent as George and some of the other people who've actually done that. We will see more people going into outer space, do more stuff, do more things that we might not think about, like marrying in space, or doing a contract in space because they might think they get outside of tax authorities. So I think the approach has to be much broader than what is addressed so far under suborbital flight. We already spoke briefly about the extension of the current suborbital hops, which I basically consider a kind of sophisticated bungee jumping, with all due respect, George. But that, of course, if you extend that from flights from New York to Tokyo, is that still suborbital? It may reach orbital attitudes, but it certainly doesn't complete an orbit until orbit. So there's a gliding scale there. I think it's very important to create a fundamental system, and if only to make sure that the United States somehow is going to exercise jurisdiction on board. If we look at the International Space Station, and this will be my last remark on this point, we have noted that there is the very general rule following from the registration convention that every country registers its own module to the space station, which was considered sufficient to regulate all the legal aspects of what was going on there, except for two things where it was necessary to go one step further. One is IPR. There's an article in the ISS which arranges how patent rights would be dealt with, and the other is criminal jurisdiction. And again, if we get less decent people than George on board of these flights, we need to be prepared for that, but we need to be prepared for much more, I think.
And can I hop in on that point? I did first want to clarify, lest there be any misunderstanding about my previous comments. I think that some sort of regulatory framework for these in-space commercial activities is necessary, and I think is appropriate for creating that certainty for operations that's going to help the business case moving forward. I may have gotten a little sidetracked or focused specifically on the crew health aspect of things, but I think more broadly, when we're looking at these operations and expanding the idea of human safety, I think we do need to be cognizant of both other humans who will be living and working on other space stations, both national and commercial. We see the Chinese have their own with the Tiangong space station, as well as these planned commercial space stations. So, and also broader than that, and there needs to be some sort of governing of activities for space sustainability, for something to govern operations with an eye towards orbital debris mitigation for these actors as well. I mean, I think that there's it was discussed on the previous panel. I think that satellite operators are already well versed in this area, and so it's something that these commercial space station operators also need to be considering in their business plans as well. And so I think we'll also need to be something that is looked at when we are discussing any type of mission authorization regime. Just wanted to clarify to that point, but also to put on a little bit of a former prosecutor's hat here as well onto the topic of criminal jurisdiction, because right now we've under Title 18 of the U.S. Code Section 7, it does establish spacecraft as part of this special maritime jurisdiction for the United States, but it only covers certain types of crimes like murder, manslaughter, maiming, kidnapping, rape, assault, and robbery. Now, hopefully, nothing like that ever, never occurs on any of these commercial space stations, but there's also there's a wide array of crimes that are covered under U.S. federal law other than those. So how are we going to address crimes outside of that short list? So just some food for thought on that as well.
I'll try to wrap this up in a bow a little bit, because I actually think, at the risk of being too optimistic, I actually think we're all agreeing with each other. And I think this is important to note. I think it's important to sort of recognize when there is maybe not consensus, but like a tendency within the space community. It sounds to me like what everyone's saying, and I've heard this now from Franz and Jessica and me and George, that when it comes to rules about, let's say, self-regarding actions, things that only affect you, your own safety, you deal with that in one way. And that's, our current suborbital regime is basically about that. Obviously, you also regulate launch and reentry to make sure you don't crash in someone's house next door or something. But in terms of, that's sort of currently how we regulate self-regarding actions in space. But then you have the whole, like, what affects other people, other regarding action. That's what the rest of space law is about. And like Jessica just said, other space actors have tons of experience with dealing with that, mostly satellite operators, and mostly not the crewed folks. So we don't have to sort of reinvent the wheel here. And I think we have a lot of examples on how you would deal with that and how you would govern it. So I think the model, at least in my mind, what I'm hearing in this panel is, when it comes to how you regulate the participants themselves, yeah, maybe you could at least use the existing suborbital as the basis for it, or sort of learn from that. But when it comes to how you regulate how people interact with the rest of the space community, no, that's not what that's about. That's, you're going to need to look to existing law and sort of build up new rules for that other regarding action category. So you got to sort of keep them separate in your mind, because people really do get sidetracked by the human safety part of it. And to be frank, as a government lawyer, that's not what I worry about. I don't worry about whether some billionaire ends up dying in space. What I worry about is whether they go and steal some other billionaire's satellite or commit intellectual property theft or whatever. That's the really hard problem.
I think we are pretty much all in agreement, but just to clarify a couple of items, it's important to recognize that commercial orbital human spaceflight is already taking place. Again, SpaceX has launched 6 crews of NASA and international partner astronauts under FAA license. We've had the Inspiration 4 flight, 3 days in space, and Axiom 1, and lots more on the horizon. And also, there really are no existing suborbital human spaceflight requirements other than things like informed consent and training for emergencies. So from that perspective, orbital and suborbital spaceflights are basically treated the same under the regulations. Also, there are no medical requirements for passengers, or more precisely, spaceflight participants. There are some for crew, either for suborbital or orbital flights. So with that understanding, the only real difference for orbital flights is the duration. So accommodations certainly need to be made for eating and sleeping and the addition of some kind of waste collection system. But from a legal perspective, we've got the system in place today. We might want to change it, improve it, enhance it, but we've got what we got and it's being used.
Well, I would just add that I was really struck by Franz's description of the difference between suborbital and orbital, especially the duration when people are going to be up there. And I was very intrigued by the question about whether or not there need to be medical requirements, because of course it's different if you're taking a 10-minute hop up to the Von Karman line and back again, or if you're going to spend 6 months up in space, or if you're going to go out on the spacewalk. And when Gabriel was talking about self-regarding, if you don't disclose that you have a medical condition and you go up for a 6-month visit and then you become ill, then you're affecting other people. So it might have been considered self-regarding because it was only about the risk to you, but it also is impacting everybody else who's up there. So I think that there is a real difference between suborbital, which is quick and it's over. And if something bad happens, not to get morbid about this, but if something bad happens, the people who are dead are here on Earth. And if something bad happens in space, they're up in space. And so do the companies make an agreement with the loved ones of what's going to happen to someone who passes away up there, whether they have to bring them back to Earth or bury them at sea, so to speak? I don't know if those are regulations, or again, if they're voluntary standards, or if they're just business decisions. But again, I just think all of this discussion so far is underscoring that the missing link in this is some government agency who has responsibility for mission authorization. And we've been waiting for that since 2015 as well, because I think there needs to be an entity to sort of bring all of these factors together and try to sort out what's a business decision, what's a voluntary standard, what's a government regulation.
And the vice president tasked the U.S. interagency to do this. At the last National Space Council meeting, Vice President Harris tasked us with doing that work to work on authorization and supervision systems. So the interagency is working on that, obviously not just for human spaceflight, but for all kinds of novel space activities as well.
Yeah, I think all the agencies had to get back to the Space Council by March, but I don't know if there's a date for when it comes out of the Space Council.
Yeah, I'll stop talking about it right now. I was just going to mention that the vice president said that we were supposed to do that. Yeah.
So you guys brought up the criminal jurisdiction a couple of times. So I was going to move to that with respect to the operation of the ISS. So a number of the legal issues, such as criminal jurisdiction, were addressed in the IGA, so the International Space Station Intergovernmental Agreement. So private space stations will be operating without that benefit. Does this present any challenges, or how do you guys think that we should move forward with that?
I think actually it's a benefit in the sense that you don't need a complicated arrangement for a station which is launched under the authority of just one country. The main reason for the IGA is that we have currently 15 countries, including, interestingly, so far still Russia, which have to cooperate and make sure that everyone works to the same standards, including legal standards. So I think the task is much easier if we talk about a space station which is going to be launched as a single space object, because then it's only going to be registered by a single state, which for the time being, I think, except for the Chinese example, will be the United States. So I think it merely requires what I believe George was alluding to, making, and Marcia pointed out as well, making some agency in the US responsible for that, making clear that the US is going to exercise its jurisdiction over that, and how it then fills that in. For example, going to Jessica's point, noting that the criminal jurisdiction, which is currently applicable, may not be sufficient to cover all that we want to cover. That's then the next step, I would say.
Yeah, these are domestic law problems to solve, right? Largely, these are domestic law problems that you can solve, as long as you're talking about one country. So for better or worse, it's going to sort of like fall into the United States government's lap and US Congress, frankly, about how they want to resolve this question, since they're all US, probably going to be US registered CLDs. Yeah.
And that was just going to be to my point too, that this is going to be the role for whichever agency ends up having this mission authorization authority, but would just note that kind of expounding on what Marcia and Franz had already been speaking about, I think it really comes down to understanding what the scope of that authorization is going to look like, because I think some of those topics that were covered under the IGA, and for example, intellectual property rights and how that regime is handled could also be covered under private contracts with the customers who will be taking part in activities on those commercial space stations.
So we keep talking about an agency. Does anyone have a proposed agency, or what that authorization or what that authority should actually look like, and where it should lie? I think Dr. Yield, you'd mentioned going back to Transpo.
I think DOT is a great choice. In theory, you could do it almost anywhere, but again, especially if you're talking about safety as being one component, how do we handle safety for aircraft and ships and trains and cars and so forth? There is an entity at the Department of Transportation that does it. And that doesn't mean it has to be bureaucratic or prescriptive regulations or any of that, but at least that is the framework that we've chosen to use for other modes of transportation.
George, would you call, just a question, I'm not disagreeing with you, but would you call somebody staying for 3 months in a space station, would you call that transportation? I mean, obviously they're flying with an incredible speed and see a lot of different visions, but is it transportation in the sense that you talk about that?
So great nitpick, if you will, but I mean, after all, the office since 1984 has been the Office of Commercial Space Transportation. So does it count? Well, maybe someday when we have this permanent settlement on the moon or on Mars, we'll have a Department of Housing and Urban Development for Mars or whatever. But again, for right now, I think you can draw the dividing line at the surface of the Earth, and you can say people that are on a space flight is part of this organization. You can give it a different name if you want, but it's under Department of Transportation. Maybe it's commercial space operations, maybe it's commercial space activities. We can finesse the title of the organization, but I think right now, most of it is transportation, and that's where the history has been.
Okay.
So I'm not going to weigh in on that.
If it was an easy choice, it would have been made already. So both departments, I think, have a lot to say for them. And at this point, it's just a need to make a decision. One way or the other, pick one.
I'm obviously not going to weigh in on that fight between agencies or that question, but about agencies. Marcia's absolutely right that the decision needs, and the decision has supposedly been made several times. Different members of Congress have proposed legislation, different administrations have taken different positions. But from, let's say, like the operator perspective, and now I'm going to sort of hopefully put on a little bit of a commercial hat as well as a NASA government operator hat, because we work so closely with our commercial operators, especially now for things like CLD. And it's CLD that really makes me worry about this current lack of regulatory authority. We desperately do need to answer these questions. Because, you know, right now, for example, let's just focus on CLD. I'm also worried about things like CLIPS and lunar operations. But just focusing on CLD, NASA is currently putting a lot of money and building an entire LEO plan around a commercial model that no one in the US government can currently say, yes, that's allowed, right? Like, that's concerning. That's concerning from NASA's perspective, that there's no regulator that can give a big thumbs up to that activity, even though that's our entire point for LEO, at least. You can make the same for lunar operations. So yeah, that's I think I agree with Marcia that is job number one.
And of course, there are a lot of people that can say no, but nobody that can say yes. So yes, good point.
Exactly, and you can say no sometimes for substantive reasons, but sometimes you have to say no because there's no one who can make sure it's okay. Right? If there's no one who can make sure that you're not about to violate the Outer Space Treaty, for example, then maybe you have to say no just because you don't know. And that's a terrible outcome, right? That's not the outcome the community, that anyone in the community would benefit from. So yeah, so we need some kind of regulator, hopefully light touch, hopefully flexible, obviously needs to learn from experience and not go overboard. But they do need to be able to do some bare minimum things, so that we can move forward with our commercial partners. Yeah.
And I'll just add on to their no for the sake of because we don't know is definitely not something that industry wants to hear. So to echo, I think everyone's comments here, industry just wants some sort of clarity and direction on this question, as well as if we can stick to performance-based standards rather than prescriptive standards as far as, you know, regulatory requirements and appropriate scope. That I will also note, because I have flashbacks to the interagency review process for commercial remote sensing, a scope that also I think appropriately limits that interagency review, so it doesn't allow for it to go on indefinitely. Those are the types of considerations that industry would also find important.
Moving on to another not clear or knowing what the direction of something is. What is the outlook for the ISS, and will it be privatized in part or in total, or will it be fully decommissioned and deorbited? What are your guys' thoughts on that one?
So I know a lot of people have been arguing for, gosh, NASA needs to leave it up there and it can be a museum, or people can use parts of it or sell it to somebody or lease it out. That sounds good, but it really isn't a practical solution. It takes a lot of people and a lot of money to keep the space station operating safely today, and whether there's people on board or not. And most of the major components that make up the station have definite lifetimes, which is what has gone into the end of life predictions of 2030 and so forth, and are not easily disconnected, repaired, or replaced. If the suggestion is, well, why don't we just boost it up to a graveyard orbit so that it won't re-enter? That would take a huge amount of support, basically, like I've heard the number 10 progress missions in order to boost it that high. And again, that's not cheap. Who's going to pay for that? And so, although it sounds like, well, why would we waste this? At some point, if we're not willing to pay for its upkeep and its safety, then it is going to re-enter. And if it does re-enter and damages property or hurts or kills some citizens on the Earth, then the United States government and the other partner governments are liable for that. So I don't think that's a practical solution to leave it up.
Yeah, George pretty much got it. And that's why our current plan, you know, is we're initiating development of controlled deorbit systems, right? A way to do that safely and responsibly. Obviously, there are sort of other physically possible solutions if you had enough money and enough time. But that would all come from something, right? That money and time would all come from some other activity. And some of that might be the commercial alternatives. Some of it might be exploration. Yeah, so I think George's points are all really, really important to keep in mind. Also recognize that you know, the geopolitical environment is such that we may not be able to rely on, you know, the Russian partner, and we can't predict that. And that's who's basically been providing boost, not entirely, but most sort of reboost for the station and most propulsion in general. So if you're in a situation where you don't control the whole thing, and you may not be able to rely on your partner, you certainly can't predict what you can rely on years out. And it takes years to develop a technology and hundreds of millions, if not billions of dollars to do this stuff. You know, it feels like there's only sort of one currently available responsible thing to do.
Yeah, and to beef up both what George and Gabriel said, if anyone has the illusion that by privatizing it, the United States and the other states could get rid of their liability or responsibility, the outer space treaties are pretty clear on that. It remains, even if it's fully private operated, it remains, you know, the liability of the launching states, including the US, and it remains the responsibility of the US, certainly if it's a US private operator. So I fully agree. I'm not an operational guy, I'm not an engineer, but I fully agree that with George and Gabriel that these are the only opportunities that we should take seriously.
Okay. Also, the private stations are going to be way more fun from the perspective of, well, let's say private actors, right? ISS is a laboratory. It is a scientific and engineering laboratory. For those of you, if you've seen pictures of it, like, and there's equipment hanging from every side and like the corridors are, you know, really narrow. It's not optimized either like current technology. It's not optimized certainly for tourism, and it's not optimized for things like manufacturing. So although companies like Redwire and NanoRacks and others have managed to sort of squeeze out really useful commercial opportunities from ISS, it is not optimized for that. So, you know, a new station would allow you to take advantage of all the technological development you've had since then, and optimize it for, you know, a mixed use scenario in a way that ISS wasn't.
The only other thing I'll add to that is that with the number of actors who are looking at building their commercial space stations, and frankly, I hope that we are all successful in it, that it's going to provide option, that it's going to provide choice for different activities and different optimizations. I mean, I think one of our priorities still, even while we are looking to, you know, aspects of space tourism and other commercial uses of our space station, I think our primary focus still is on research and development through our entity, the George Washington Carver Science Park. So I think that's always going to be a focus of these activities, at least from the NanoRacks perspective.
I do want to throw out one sort of wrinkle, and this is more like a problem for the community to admire. And it's a downside of the transition, or at least a challenge from the transition to ISS to CLDs. ISS, because of the international part of it, one way that money and resources got plugged into that system, literally plugged into that system, was through barter, right? ESA and Japan and Canada could produce hardware or do a thing and get flight credit or back and forth, right? You could sort of trade in that way. It's hard to imagine that system translating well to a CLD perspective, right? If you've got a commercial company, they don't want an in-kind contribution, or maybe they want some, but not that many. They need money, right? Like they need to sell their services. So I do worry about whether it's going to be hard for these CLD companies to have the same international breadth of customers that ISS currently has. You know, if a Japanese company wants to do something on ISS, they can work with JAXA, and you know, JAXA can then do a barter thing with NASA, and Japanese company can get on ISS. If the Japanese company wants to do something on the CLD, presumably they just pay to do that. which is fine. That's how that's how capitalism works. But that's not actually how the LEO economy has worked entirely so far. Moving from a barter system to an actual cash-based economy means that money may transfer, for example, from Europe or Japan to the United States. And that's not a thing those regions or governments have been keen to see happen, particularly in the space context.
On the subject of working with international partners, well, I think the methods and discussions, which I think all of the different parties are talking to potential international partners, I mean, that's all proprietary to each company, and we'll figure that out. But I think one of the underlying foundations to be able to even engage in those discussions is export control reform, and specifically, I think, extending the types of exemptions that exist under the EAR for space station. Specifically, right now it's the ISS, but extending that to broader space station activities. And I'll just lay that out there for any response.
I think so normally we were going to go to audience questions, but we don't seem to have any. We do have the poll there, so everybody going for CLE, make sure you're clicking your buttons. I just wanted to see if everybody kind of wanted to give one last final quick thought of where they want or what they think for orbital human spaceflight and then private space station. So just a quick, maybe 30 seconds of your final thoughts on each of those. Dr. Neal, do you want to start it?
So it is here, and the transition from ISS to the commercial stations is going to make that clear to the world. I think it's a very exciting time for commercial space right now, and we just can't afford to sit back and ponder some of these issues. They need to be resolved now. We need to have people talking about them. We need to make the selection on who has the authorities from US government and other entities. And then it's going to be up to the providers to decide how they want to handle things. And that's going to be a major shift from how we've been operating on board ISS and so forth. But I think it, in the long run, could be mutually beneficial to the governments, to the space agencies, to the public, and to business and academia as well.
I'm going to keep going just down my list. So next up, I've got Jessica. You want to give your final words?
Listen, it's incredibly exciting to be working for one of these companies that is designing and building a commercial space station right now. But I think to Dr. Neal's point, industry does need some clarity on what the regulatory regime is going to look like. And one thing I wanted to also highlight, because I saw Charity Whedon commented in the chat, when we're looking at a regulatory regime, concept of assumption of approval words is so important. We do want to make sure that that all of the actors that are going to be in this realm are acting responsibly. But we also don't want to overregulate to the point that it kills this business before it ever leaves the ground.
And Marcia, you want to give yours?
Well, I would just, again, foot stomp the idea that the time has come, if it has not long since passed, for a decision to be made about who's going to have mission authorization responsibility. To me, that's the big missing link. It's often said that legislation and regulation lag far behind technology, and this is certainly another one of those instances. You know, the train has left the station, and I think that for the sake of the companies and the sake of everyone else, we need to have someone who can bring all the parties together and figure out what needs to be regulated, what needs to be a business practice, what needs to be a voluntary standard, and really start nailing them down.
Gabriel.
Yeah, from the perspective of sort of NASA as an operator, we are losing control over LEO, and I don't mean that in a bad way. I mean, this used to be, particularly with human activity in LEO, this is something that we largely controlled, or at least governments did. So we're transitioning away from government control, which creates a lot of vulnerabilities. Vulnerabilities on the regulatory side, like Marcia said, like we don't have a full regulatory system yet, so that's a possible failure point. But also, to go back to one of my first comments, we also now have to worry about business models, and we have to worry about, what is economically viable for our private sector partners. And that's another potential failure point. If all the best technical plans in the world might not work just because they don't make money. So from the perspective of a government operator, we are having to think about things that we've never really had to think about before. Now that we're sort of moving into this new world of commercial activity. So it's not a great thought, other than to say, like, those are the kinds of things we're worried about or we work on now inside NASA, which is a new way to think about, building the space economy or building the space community, where previously it was technology and sort of leading the way by what you do. Now it's trying to create this conducive environment in a lot of different ways. So, people who are involved in government work need to sort of recognize that the job has changed.
And then Dr. Franz.
Yes, it's dangerous to give a law professor the last word, but I will keep it short. I first of all, I echo what everyone has said so far. I think these are exciting times. Lots going to happen. To which I would only like to add two thoughts. First, it means that specifically for the law students listening, this is a great time to study space law. We need a lot more of you guys and gals in the next 5 to 10 years. So make sure that you're in the front line when these things start happening. And the other thing, it echoes a little bit what in particular Marcia said. I think we should hurry in getting our act together in the United States. It would be a shame if China would steal the thunder by getting the first regulation of a commercial, or at least a officially non-state civil space station out there. I think it's important to make sure that in this respect, the United States will continue to lead by example rather than just follow what's going on elsewhere. So thanks everyone. Unfortunately, I have to bail off. So thank you for the invitation. Thank you for a great conversation. I look forward to seeing all of you again at some point. And Mark, enjoy the remainder of your birthday.
Yes, thank you to the panel again. I feel like I could have spent an hour introducing each of you guys. So just thank you for your time and your insight. I'm sure if this wasn't Zoom, you would have a standing ovation right now in the room. So I'll just clap for you. Thank you. And then now to go on to the next panel. So you guys can go ahead and then turn off your cameras, and then everything will be from there. So thank you. Mark, I'm going to go ahead and hand it back to you for the third panel.
Thank you so much, Stephen. Well done. And thank you to all the panelists. I'm a little bit jealous that I was not the moderator for that panel, but I need to share the pleasures with others. Great job, fascinating issue. And again, my thanks to the panelists. And now it is my honor to introduce the third panel, which will change gears. Before we enter into it, the topic is rendezvous, proximity operations, and docking. And this contemplates the new segments of the space society, the space industry that will deal with the interaction of space objects. And it involves a refueling on orbit, repair of satellites or other spacecraft on orbit, docking. We need to make sure that there are standards so that whoever provides the delivery service and ferries crew to a private space station will be able to dock with that space station. And so we need standards, and that's not a new topic. It's something that has to be faced by every industry. But now with the emergence of these on-orbit operations of a different nature, where we will see spacecraft interacting, we need to start giving thought to standardization so that we can all work together, speak together. and cooperate and interact. And so that is what we're going to be talking about over the next 45 minutes. Before I go any further, I would like to introduce the panelists that are joining us here. And I will start with Mr. Mike Gold, who is Vice President at Redwire, one of the great space conglomerates that is financing and supporting so many of these modern, innovative space applications. So we're fortunate to have Mike here. He has, those of you that are familiar with Mike will know that he's worn many hats over the years and worked in government and private industry, and is also a trusted voice in space law. So thank you for coming today, Mike. And we also have Sagi Kfir. And Sagi was, when I first met him, he was working for one of the pioneer space mining companies, Deep Space Industries. From there, he went on to Blue Origin and is now providing private consultation and legal services to the space industry. It's wonderful to see you here, Sagi. Thank you for coming. And Mike Wall, those who follow space, even if you may not know why, you should be familiar with the name Mike Wall, because he is in the byline of many of the great pieces written in our press about the space industry. And so in the New York Times and others right now, he's affiliated with space.com. So he has certainly given a great amount of thought and gathered a great amount of information about the space industry. So we're very happy for his perspective today. And then finally, Ryan Noble. Ryan is right now working with Hawkeye 360, a remote sensing company, but an orbital remote sensing company. So he fits in very well with the panelists today. And he, as the other panelists have, has broad experience in the space industry, and it has a sharp mind. And I'm very glad that Ryan's here with us today. So we're talking about rendezvous, proximity operations, and docking. I have to maybe remind the panelists, who are all longstanding experts in eat, drink, and sleep space law and policy, that many of our audience members are not so informed about the current state of the space industry and the nature of international law. And we have plunged them into the heart of the storm with very little preparation. So I think we should all throw out a life raft from time to time and help explain terms like CDL, which is a commercial destination in low Earth orbit. So in that spirit, I am going to ask this first question to kind of give the audience an opportunity to get a broader understanding about what we're talking about when we're dealing with proximity operations, rendezvous, docking, interoperability, standards. They are obviously a key issue, not the only issue that we'll be talking about, but a key issue. And my first question out to this group is, where are we seeking standardization? I think it's clear that if we're going to have refueling in space, we're going to need standardization of the nozzle and the receptacle for the nozzle. How are we going to transfer this fuel? There must be standardization, just as there are on our automobiles today and the gas stations across the country and around the world, really. There would have to be standardization of the type of fuel used. If you're going to provide fuel to the world of satellite operators, it needs to be fuel that they can use. Grappling, to actually rendezvous and take hold of a satellite so that refueling or repairs can take place. There needs to be hardware that can be grappled safely without causing any harm to the satellite. Repair. How far does repair go with standardization? Are we talking about having standard off-the-shelf components to spacecraft? And to what level, to what depth would such standardization occur? If everything can be unplugged and a replacement plugged in, I imagine that would be optimal. But the more standardization, of course, that's required, the more difficult it is. So have I really explained the challenges of interoperability in RPO situations, or can our panelists add more to it? And I will just, to get the conversation going, I will ask Mike Gold to take the first stab at this question.
Thanks so much, Mark. Did I hear it was your birthday earlier?
There's a rumor going around, yes. You can...
Well, in deference of not scaring away the audience, I won't sing you happy birthday, but happy virtual birthday. What a great way to celebrate.
Thank you, my friend.
So relative to interoperability, let me begin perhaps with where I think we've been successful, which is docking standards. Of course, for two systems to come together, particularly human spaceflight, you need to be able to dock. And NASA has developed an ASAT docking standard and has broadly and widely shared that standard, allowing multiple companies and even multiple countries to be able to utilize that. So I think that's a great example of interoperability leveraged in a positive way, in an open way, which is terrific. And the importance of interoperability generally, and I think you gave a great summary, Mark, not just saying that because it's your birthday, but imagine, AC/DC, and if everything, half of our system space were AC, the other half were DC, how difficult it would be. VHS versus Betamax for those of us who are older, DVDs versus Blu-rays. Without standardization, the robust commercial space industry that we all want to see will certainly struggle, if not fail. That we need standards, we need interoperability to achieve this vision of, again, robust commercial and government activity that all of us in government and the private sector are all trying to achieve. And I think the docking standard is a good example of that. Where we are less mature is in the area of satellite servicing and satellite refurbishing and everything we'd like to do with ProxOps. Again, we're at this unique moment in history where robotics and satellites and 3D printing are all coming together to create something entirely different. But we need standardization, we need interoperable standards to do that, even if it's just a QR code for satellites to be able to recognize each other. So we've got a lot of work to do. I was on the founding board of Confers. Redwire is still a member, which is a group that was initially created by DARPA to tackle this very issue. So there are those in industry and government coming together to try and address that issue. Confers as an example. And I think the more we can do that, the better off that we'll be. The challenges that I see are, as always, export control. I can't go 5 minutes without mentioning that. But particularly when it comes to interoperability, there is the potential that you are revealing, quote unquote, technology. So we need to be cautious of that. Not so much that I worry about it per se, but that it can become a hurdle that we need to get over if there are aggressive interpretations of what export control is. And then it's just a matter of finding a way to coordinate it, which can be very difficult as well. And I'll end by just saying that while, again, I think interoperability is critical, obviously we wove that into the Artemis Accords, just that Gabriel on, and we worked together to put interoperability in. It's an important principle, but you can always take anything too far, right? That even interoperability taken to an extreme can be difficult. So I think we always need to make sure that we hit a balance where we aren't creating a chilling effect on innovation in orbit, yet at the same time, again, interoperability is foundational to building this robust future that we all want to see.
Excellent. And for the audience members who may not be familiar with CONFERS, it stands for the Consortium for Execution of Rendezvous and Servicing Operations. And it's one industry group that is trying to create these standards. I'll open up the floor if there are any preliminary comments that want to be made to set the stage by our other panelists. Or I'm
Just
also.
glad, Mark, you gave the acronym. I would have screwed it up, so I am impressed and
Yeah,
appreciate
well, I pulled it up online, so I read it. It may appear that I pulled it straight from my memory bank, but that was an illusion. Yes, but I would like to continue to set the stage, or maybe it's set, but I would like to give the other panelists a chance to chime in, just jump in, and I will moderate any interference.
Yeah, well, Mark, I'll be happy to chime in. And by the way, happy birthday. Thanks for the invitation. We all greatly appreciate you as a person and a leader in the field. So thanks for bringing us all together. You're a mensch, as they say in the mother tongue. I think you asked a little bit about the technological aspect of interoperability, and I think it's dangerous to have an attorney try to articulate technological issues. So thanks for throwing us into the mosh pit. You know what? Let's talk a little bit about acronyms and about RPOD and everything else, because like you said, there are probably a number of people in the audience that don't have that deeper background. I think, and correct me if I'm wrong, I'm happy to discuss this with anybody. RPOD encompasses a lot of things that you mentioned. There's also ISAM, which is in-space servicing, assembly and manufacturing. You'll hear that being thrown around. There's ADR, there's active debris removal. All of that is involved in RPOD. There's more, and by the way, just so we're all clear, right? RPOD is not a new thing, right? Like, there's been RPOD missions, or at least human-rated missions, been done since the beginning of the space missions. Gemini 6 and 7, I think back in '65. And Gemini 8 did the first targeting with a docking with the target. So it's been around for quite some time. But in terms of the actual critical technological issues, there's a number that you talked about, Mike addressed, especially docking. There's navigation guidance systems, there's communication systems, there's control systems. There's a number of things, even including propulsion systems. When we talk about critical technologies, you talk about capture mechanisms, and Mike talked a little bit about it. That seems to be the sexy and potentially nefarious aspect of RPODs. You've got the grappling systems, you've got harpoons and nets that have been used. I think that was the removed debris mission back in 2018. So there's a number of different technologies that are being talked about, used, flushed out. And I think over time, that's going to work in terms of what works best for interoperability. That's what I wanted to jump in and say right there.
Thank you very much. I appreciate the kind words. Mr. Wall, Ryan?
Yeah, I would just, these different topics cover such a breadth of information and implications. And so I'm not more on the technical side. I'll leave that to some of the other panelists, but I'm just kind of interested in what the implications of some of this stuff kind of might be. Obviously, I'm not convinced necessarily how important satellite servicing and refueling is necessarily going to be for the in-space economy, given how we're seeing more and more satellites get smaller and more capable and more sort of disposable, as you might kind of term them. And with launch costs going way down, do the other panelists, just out of curiosity, do you see satellite servicing and refueling as a major driver of the space economy going forward? With that trend, or do you see it as something sort of niche, and that's just one aspect that will be used by sort of big, powerful space missions, but not across the industry as a whole?
I'm happy to take a swing at that, Mike. I think, as always, nomenclature restricts us a little bit. When we say satellite servicing, I think we really should be talking about refueling in general. And as you look at particularly cislunar activities, refueling is going to become more and more important. Satellite servicing, I think there's always going to be a role for the larger satellites in GEO, and servicing, replenishment, I think there's an opportunity there. But I would say more broadly, we are definitely going to be leveraging refueling, refurbishment as humanity pushes forward in cislunar space on the moon itself. So that's where I think all of these issues become incredibly important. I mean, even just look at power and where we'll be commercially with CLIPS missions, iSpace, is about to land soon. And then I think there's already a robust interest in grapple capability. I'll just kind of leave it at that in terms of grapple. I think we have a good friend Jeremy from Rogue Space on, and they're doing some really interesting things. And you see Space Force, really looking at ISAM. And I think for ISAM, the first portions that we're seeing great interest is in the in-space servicing and assembly. And assembly can even include building some of those small sats in space. So I think it's going to be much broader than satellite servicing. And this is going to be different than probably what we're imagining, but I do think there's a robust future for all of this.
Yeah, I'll jump in here too. Yeah.
Yeah.
Having spent my space career in LEO, I think there is two different ways to think about those regimes. So as you were saying, as we expand into the cosmos, refueling is going to be very important. My experience with the kind of small satellite class distributed constellations that Mike was talking about, refueling becomes less important in my mind because having worked the portfolio of space segment procurements, if I could get a payload components and a bus subsystems that functioned according to their performance spec long enough that I would be interested in refueling that satellite, that would be a dream. And so I think replacement of failed components that do not perform the full mission life is an interesting area, even for sort of those distributed smaller satellite class platforms. And having spent time at a lot of startups, if the capability is priced appropriately and available on a time scale that has a meaningful economic impact for a startup, that could be a make or break, right? And so something that might be of interest. If you're working with 20% of your baseline business case distributed constellation, only 20% is up, and half of that has some manufacturing defect, and you're able to swap out components and return that to service, that could have a big impact on the future viability of that entire business case, right? Or if you're halfway through a constellation deployment and realize that you'd like to make a vendor change in one of your components because of long-term reliability, and you're able to do that on a go-forward basis for the remainder of your launch campaign, and then maybe retroactively a little bit with in-space swapping of components, that can have a major impact on the total economic value of that constellation as you're looking at maybe a 5 to 10 year operating life. Recapturing that 5 years on the books, right, that starts to look really interesting. That might justify the expense of an in-space servicing as opposed to deorbit, burn, and just replace, hypothetically.
Excellent, excellent. Thank you. Great. You guys rounded out the issues. And for the audience, just to ensure you understand the importance of refueling, although one of our panelists just said that that is one of the less critical issues, and that's why I invited him. That's why
Leo versus deep space, it's in the moon, it's cislunar.
Yeah, no, I like I curate disagreement and dynamicism, so I'm glad that we had that perspective, because it was a surprise for me, but I see it now. But for the audience's purpose, why do you need to refuel satellites? Because they are not immune to gravity, but are constantly in free fall to some degree and need to be boosted from time to time in order to remain in orbit. And so when the fuel runs out, and we've seen this with massive satellites, and they run out, they are then in free fall, uncontrolled, into the Earth's atmosphere. And so it's by refueling, you extend the life of the satellite. Definitely. But Ryan mentions another important point. I thought that you can upgrade satellites, not only repair broken satellites, but you could upgrade satellites, replace older parts, and really extend the life of a satellite that way. Very interesting. Now, the next question I have is, who's working on this stuff? And I'm aware that there's the Space Safety Coalition that is working on space traffic management. There's Confers that's working on interoperability. Who have I missed? Who else is working on this issue? Are there other groups, and in particular, are there international groups that are working on this? And I'll just toss it out to you, gentlemen.
I think there are a number of groups that are working on this. In fact, I think the first panel was talking about standards that are being worked across the board and across the aisles and across different governments. Other than Conference, and Conference is one of the leaders, obviously, right? Because it's they're an industry-led consensus, non-binding standard group, which I think was actually started by DARPA, right? By a government agency. And they've developed a number of guideline principles for RPOD. And I mean, what would ISO be without another standard, right? In addition to, I don't know how many standards the International Standard Organization has, but ISO, I believe, just released last year a standard on RPODs, 24,000 and something, that's their standard. And Mike mentioned earlier, obviously, NASA has historically set standards for RPODs with the ISS RPOD, ICD, the interface control document, and ESA is definitely working on that. From my understanding, they've got the Close Proximity Operations Working Group back in 2018, and I think even ESA is working with Confers and with ISO, so they're working across boards. And I mean, even to the point where this is not as tangential, I think this hits home. Even OSTP, the Office of Science, Technology Policy in the White House, they've got the 2022 ISAM strategy. And the ISAM strategy, obviously they were talking particularly maybe from the administration's point of view about sustainability and environmental sustainability, like you were mentioning, keeping satellites in space and having them not deorbit if we don't need to get them deorbited. And if I recall correctly, there's a number of goals in that OSTP ISAM strategy, and I think there were like 6 goals, 5-6 goals. And I think one of the challenges they talked about in those goals was establishing and adopting standards to help promote commercial growth. So the government is looking at it, and definitely the FCC is looking at it from an ISAM perspective when they're looking at licensing. They're obviously looking at it from orbital debris mitigation as well. So I think there's just a number of different groups that are looking, and I would be remiss by not mentioning and giving a shout out to Mike Gold and Artemis when they talked about interoperability standards in the Artemis Accords.
And for those who aren't aware of the drafting history of the Artemis Accords, which are the governing documents that set forth standards for the partners in the Artemis program, Mr. Gold, along with our former panelist, Gabriel Swinney, were leading drafters of that document, which is one of the more exciting developments in international space law. But again, it has to do with the moon. So it's not the focus of this symposium, but it's a great model for future agreements as well. So thank you for that, Siggy. It's almost as if you got that question in advance. Are there any other?
Maybe I'll just comment quickly,
maybe.
Mark. And again, let's say the Accords, it took a village, right? Partner in crime there, Gabriel, who was at the Department of State at the time, just a tremendous legal mind. Although on your birthday, Mark, I do have to echo the comments from my fellow mensch in terms of Sagi that, the work that you had done, Ski had done, that everyone did at the Hague International Space Resources Governance Working Group helped lead up to the Accords. So again, a lot of joint efforts, and interoperability was really important there. And in terms of who's working the issues, so you've got the trade associations engaging now with the Commercial Spaceflight Federation, AIA, AIAA. But I want to highlight what the government is doing. We had these conversations many times at Confers that the government really has control, because the trade associations or other groups can establish voluntary standards, but we're all going to work to what the government wants to do. So for example, at Redwire, we're building the international berthing and docking mechanism for the gateway in our Belgian office. And that's being driven by requirements that we're getting from ESA and from NASA. And the government is therefore de facto setting what the standards will be, whether they'll be open or not. So I just want to emphasize the government role that as contractors, we're going to build to suit, as we are on Gateway and as we will on commercial satellites. They have a very important role on all of that, similar with our rollout solar arrays, the power requirements that we're building, have deployed on the International Space Station. Our arrays will be on Gateway as well. We're on DART. Again, it would be incredibly helpful as we go forward, not only in Earth orbit, but to the moon, but to have standard power, understanding what standard power utilization, connections, interoperability should look like as a company that's building all those arrays. That would be incredibly helpful to global development, and the government, again, de facto establishes what does happen or doesn't.
Excellent, excellent. Thank you for that. That's very satisfying for me personally to hear about all of these things, but informative for our audience as well. And now, but one thing you said, Mike, triggers another question, that the government is the leader of interoperability standards. And believe, I'm a huge champion, as you know, the two of us have spoken before the UN about how well the United States government agencies involve industry. But I wonder, now I'm turning towards I'm being a little provocative now, turning towards the dark side of interoperability. And does it chill innovation in some way to have NASA set the standard and everyone is sort of forced to follow because NASA is the ultimate customer of these private companies at this point? If NASA sets the standard, then companies are not able to develop their own in an innovative way. Am I being unnecessarily dark?
No, you're just being practical. I think it's an excellent question. And that's why it's so important. And what I appreciate what Confers and other groups have done as they interface with NASA, FAA, the Commerce, other government agencies, defense, etc. The defense, NASA, they need to be intentional about what their contracting requirements are, because as I just said, we in the private sector are going to follow it. So if we're required to do something on IBM, we're going to do that. That could then become constructively the standard. And I don't think it's necessarily something to fear if our colleagues in government are cognizant and intentional that as they create requirements, those can be good or bad, right? And if we're not thinking about the implications throughout all other systems, it could be used poorly, like any other tool. Conversely, if the government is proactively thinking about, well, as I direct Redwire or any other company to build an IBDM, and we're opening up those specs and making sure that we're building something that can be used for CLDs, that then is proactively helpful. So I think, like with all tools, it's certainly a good question that you ask, and the answer depends on how intentional or not our colleagues in government are looking at the issue.
Interesting.
Yeah,
go ahead, Sagi.
So, and I appreciate Mike's input here. I think Mark, the way you pose the question, you brought in NASA. So let me be a little bit binary here. I'll make it very, very black and white. If it was just government imposed standards from NASA or otherwise, I would be concerned. I love what NASA has done. The history is rich. Interoperability is definitely been flushed out. Mike talked a little bit about it. But that's why we've got also industry-based consensus involvement, like confers. Like I remember when NASA was, so NASA's got, this is a little tangential, but it kind of brings the point of what I'm trying to say. There's a program in NASA called Subsea, so it's suborbital flights that they use commercial companies like Virgin or Blue, whoever. And there was always the concern that they would now start imposing their very flushed out, but very quite rigid standards on human launches for suborbital flights. We worked with NASA, we worked with the FAA on that, and we kind of walked them off the cliff for that because their level of standards were a lot more rigorous than what the commercial industry would have been comfortable with or was needed. The flip side is there a dark side to interoperability? I'm going to do the glass half full, right? I think interoperability, like Mike said, could have a chilling effect if not done correctly. But the glass half full is very full in the sense that interoperability helps out commercial companies on a number of things, right? You could say it enhances safety and reliability. From my history in space startups and commercial space startups, I've got war scars in terms of the bottom line. So when we talk about interoperability, helping out reducing overall costs in the bottom line, there's simplification of product development, right? It increases ease for both the operators, the service providers, and the satellite operators. You're going to lower NRE costs, non-recurring engineering costs. You have a better business case for the service provider because you can handle multiple potential customers, right? Rather than having only one satellite operator for one satellite servicer, which is not a great business model. Potentially lower insurance costs because insurers and underwriters understand standardization lowers risks. It even helps out the regulators, right? They understand a little bit more in terms of launch licensing, and when they do their payload review or they issue, they understand a little bit of the risk profiles when there's that kind of standardization. And I would say also from the nascent industry that we're in, can you imagine the concern? I would be concerned if I'm a satellite operator and I'm going to contract with a satellite service provider, and we work on particular standardization just between the two of us rather than a broader spectrum, and they go out of business in 2 or 3 years. And I built that asset, it's already flying in space, and now that doesn't work. What happens to the IP? So other than what I said about the binary, don't take a very unipolar NASA approach, look at it from a broader perspective, I definitely believe there is an upside for interoperability. There's a win-win situation there.
Yeah, I'd
Yeah.
like to.
Oh, sorry. Go ahead, Ryan.
My comments are very aligned with Sagi's, so I thought I would be a good time to follow. In my experience, the standardization, the dark side of this, manifests in a supply chain risk because you do not. A poorly implemented standard prescribes the vendor you must work with to meet that standard, and so now you've been driven artificially into a supply chain risk where there's maybe 1 or 2 suppliers that are trying to meet the needs of a diverse industry. And the cascading effects that can have is bad for everybody, right? We want to compete on the price, the product, and what we're offering, but not be squeezed in, say, some element of standardization around the launch service, or some long lead item that is necessary to integrate and launch a satellite available commercial launch vehicles, and it's produced by only a handful of parties, and you have to purchase it 18 months out. And maybe those vendors are dealing with a scaling in the demand for their product that they weren't really anticipating. They've done good business at 100 units a year. Now people are proposing thousands or tens of thousands of satellites. And we're all now relying on this little choke point. And so these, particularly in the small sat class in LEO of the segment, I think standards that allow more vendors to participate in ways that are innovative in how you meet the standard, but allow others to enter the playing field to meet the demand and give us some more redundancy and resiliency in that supply chain is for the commercial sector I would be looking out for in setting of these standards.
Yeah, I was just going to broadly agree with what both of you just said. I mean, it might chill certain aspects of technological development. You might not have as many grapplers or as many docking adapters, but it would open up the entire ecosystem to a lot more players if they could focus, kind of more of their resources, more of their energies on their own specific technologies and not have to worry about, if the baseline is already there, then they like know how to connect with that broader ecosystem. That seems to me like it would be very much like a net positive.
Excellent. I like this. I'm going to continue down the path of darkness. And we have only a few minutes left, but are there risks to interoperability? Because interoperability grants access to your space object. It allows for the grappling of your object and the maybe removal of components or other dastardly behavior. Any thoughts on that? Or am I simply going off the rails here? I think I must be off the rails. But I see someone unmuting.
Wait, it was me unmuting. I'm kind of thinking about this. I'm thinking out loud. Are there risks? Sure, there's probably some risks. There's probably some vulnerabilities, like docking and grappling. But I think those risks and vulnerabilities, again, I'm glass half full. I did my yoga this morning. I think there are opportunities in those vulnerabilities. And I think that you can have potential increase of innovation and tech solutions for those vulnerabilities. I don't know, additional encryption, authentication, access controls, monitoring system activity. I think within that interoperability, those vulnerabilities will show themselves, but I wouldn't say that's going to be a breaking issue.
Yeah, so I didn't do my yoga this morning or ever, so I'll try to continue down the dark path. I don't worry so much about interoperability as a vulnerability per se, but taking a little bit, I think, Sagi, from what you were mentioning earlier, where interoperability I think can go wrong is when it's not even so much interoperability as it would be standards. But again, you would mention maybe with someone else, but if NASA or defense establishes a standard, and then that becomes the de facto standard for commercial, that can be a dangerous precedent to set, because commercial perhaps shouldn't be using that standard, because commercial has different activities than NASA, different customer base, different operational concerns. And you've got a number of lawyers covering or otherwise in this panel, that could even become precedent for a lawsuit. So that's how something that, say, NASA puts out, even unintentionally, in terms of influencing the private sector, can become a de facto industry standard, because if you get sued, that will be the standard that we look to. So I just think that we need to, again, be very intentional and cognizant on the government side when the government issues standards in terms of the impact on private sector operations, intentional.
Yeah, I think having a diversity of approaches between our national systems say, operated by the US Space Force. And the commercial capability is important for national resiliency of all the things we do in space. I'm seeing that in the press a lot, thinking about, are there aspects that both our national space capabilities and our commercial space capabilities all rely on simultaneously? Creating a choke point in our federal launch ranges could be considered one of those. And so if you have a diversity of architectures that can make our total sort of American use and access to space, I mean, both our government and private systems more resilient, because it's harder to find one of those choke points to exploit and you'll be able to take both sectors down.
Great thoughts, great comments. This is exactly why I invited you all. This is the end of this panel, but I have one last question. And because I'm one of those who on their birthday likes to give gifts. And the question is, and the poll is up for those seeking CLE credit, but the question is, will ITAR apply if a US company replaces a component in a European satellite? The ITAR states clearly that launch into space is not an export. I don't think we're going to have disclosures. No one's going to be looking at this component. Can we evade the ITAR? And you know, it was a gift to you, Mike.
All right. So, yeah, it's not my birthday, but I'll take it, Mark. So first we say ITAR, I think in many, if not all cases, you're already avoiding the ITAR, but it would be commerce, right? It's can we avoid here? Really the question is, can we avoid export control generally, right? And I don't think that you could avoid export control writ large, because if you're going to be conducting an activity, even once we make progress on standardization and interoperability, that's still going to be a degree of complexity of a robotic system approaching a satellite, adding or removing a component. And therefore, there's going to need to be an international communication about requirements, timing, and operations that likely will be captured by export control. But since it's a birthday, and on a happy note, I hope the gift that we all get is a common sense export control regime. That there's probably going to be an export control issue, but I think we can establish a regulatory regime, and have in some cases, that will allow it to be benign and supportive of commercial activities, at least for everyone who isn't the 126.1 country. Hope everyone takes a sip of coffee when I say 126.1, but that's your bad boys international. So for most countries, I think we establish a regime where export control perhaps doesn't disappear, but at least isn't a problem.
Well done. The professor gives you an A on that answer. It was something I might ask in my
Maybe my only A in law school, Mark.
Well, thank you all. All right, we've exceeded our time limit, but I could continue to go on. So thank you, Sagi, Michael, Mr. Gold, Ryan. Great to see all of you, and thank you again for carving out time to join us today. I'm going to ask you to shut off your cameras and make room for the next panel.
All right, thanks, y'all.
Thanks for having us, Mark.
Thank you. Great to see you all. And as I ask our former panelists to turn off their cameras, I'll ask the next set of panelists for our we're already at our fourth panel, to please turn on their cameras and join us in the Zoom room. Wonderful to see you all. Thank you for joining us. And I'm going to hand over my moderating duties to Mr. Scott Perry, member of the International Institute of Space Law, as well as the Moon Village Association, and another bright light in the new generation of space lawyers. Scott, I'll hand things over to you.
Well, thank you, and good afternoon, everyone. It's great to be here, and where else can you start off such an event with birthday greetings and references to the great one, Wayne Gretzky. Dean Fisher did a great job there. But so first, happy birthday, Mark. We all wish you a happy birthday, and just another brief note of genuine gratitude for the invitation to assist today, and a quick nod to the Global Space Law Center and its council member students there at Cleveland Marshall College of Law as well. And of course, thank you to everyone participating today, whether as a panelist or a symposium observer. It's always great to reconnect, see some familiar faces, and likewise have the opportunity to meet and make new connections. So thank you all for taking the time. Before considering in greater detail our topic at hand here today, which is the orbital debris ASAT tests and decommissioning satellites, let's just take the great pleasure to meet our esteemed experts for this panel. Your accolades and resumes, I'm sure, could exceed the time we have for the session. So I'll just give a quick shout to Karen Chenoweth, Relativity Space, Charity Whedon from Astroscale, Chris Johnson, Secure World Foundation, and Jeremy Gruner, Major with the United States Air Force, Judge Advocate General. Thank you for your service, and greetings to everyone. It's great to have you here and take some time out of your day to offer your wisdom and your perspectives and your insights. And our time is notably short. I'll try to keep it on time, but so let's get started. And so I've kind of framed some of these as focus themes or issues. And the first one has to do with setting the stage is really where I'd like to go. And to do that, I would turn to the European Space Agency, and it's stated in regard to the mitigation of space debris generation that if mitigation concepts are applied insufficiently or too late, some orbit regions, particularly the valuable 800 to 1400 kilometer altitude, may experience a collisional cascading process that could render these regions too dangerous for space activities within a few decades. So, Chris, I wouldn't mind starting with you, just to begin with some general remarks from you, what the reality of the space debris concern truly is. And I turn again to the great one, Wayne Gretzky. I think this analogy with pucks, I'm picturing a bucket full of pucks on a sheet of ice, and they're kind of, bouncing around. And of course, they don't explode or that sort of thing. But we're going to get to Kessler momentarily. But for now, what are the general contributors or sources generating space debris, and sort of the basic physics behind how space objects travel and behave in space and how they interact when they contact each other?
So cold call to talk about basic physics in space flight. I think you've chosen the wrong person to start the panel off, but thank you for having me. As I think about, how we start thinking about debris in the space domain, I think you can go by altitude and look at particular orbits to see what the debris population is. You can also go divide it up into the large things and the small things. You can divide it up into those things which are created intentionally and those pieces of debris which are created unintentionally. So first, for the folks just learning space law, space debris are space objects, especially if they are anthropocentric or anthropogenic and created by humans. All of those things, remain the responsibility and potential liability of the launching state. Even the pieces of the nuts and bolts and flecks of paint, they must have came from somewhere, someone launched them. So that persistent responsibility and liability, that's what, that underpins a lot of what we're going to talk about when we talk about cleaning up the space domain. In addition to that responsibility and liability, let's first mention Article 8 of the Outer Space Treaty, persistent jurisdiction and control. Or let's phrase it another way, we don't have salvage rights in space. There is no right for an actor to go and clean up the space domain just by themselves without getting permission by whoever was the launching state of that remaining piece of space debris. So let's see here. I've divided up into large and small. I've divided up into particular orbits, and I've divided up into those pieces of debris which were created unintentionally, let's say negligently or inadvertently, because the creation of debris is what happens whenever we go to space and launch things into space. It's pretty much common practice that you can't do this without creating some debris. And we just understand that. So yeah, negligently creating debris and then the intentional creation of debris. And I think that, you mentioned this ESA quote. I'm going to guess that that's going to be somebody from the ESA debris office, like a Holger Krog or someone else from ESA who's tracking debris. And, and how much debris can we track and what size do we get down to? And then you mentioned that Kessler effect. I think that, it is grown up in the last few decades where we've really seen that this is a real concern that we need to be concerned about with and take steps to mitigate and not create any additional pieces of debris. I don't know if we've reached a Kessler tipping point in any particular orbits. But as our sensors get better for space, our numbers of debris go up, and as we can track down to 10 centimeters or smaller, that debris population of things which are trackable, and then things which are merely predicted as this is how much debris we think is in this area, those numbers continue to increase, and it's going to be a real concern. Although I invite anyone on the panel to see if they've agree or disagree with what I've said, or add some gloss onto it.
Please, yeah. If there's someone, are these objects spinning? Do they follow sort of the physics that I'm familiar with here on Earth, or what are the unique characteristics of these pieces out there? If anyone wants to contribute,
I'll take a stab at that, Scott. I think it's important. I think Chris, you mentioned size matters here. I'll give some numbers. How about that? There are about 30,000 objects that one can regularly track in orbit, and that's approximately baseball sized. And those are spread throughout specific orbits. So they're not like equally distributed from LEO all the way out to GEO. And they're in very important orbits like the geostationary orbit, sun-synchronous orbit, and et cetera. And of course, as we talked about before, there are thousands and thousands of other satellites entering Earth's orbit. And 6 decades, around 9,000 launches in the 6 decades, all spilling little pieces, all depositing their satellites in orbit, all potentially leaving rocket bodies in orbit as well. And so there has been built up a large number of objects in orbit, again, distributed specifically in some orbits, but over time, due to the degradation of the orbits, you can also descend a little bit over time, depending where it's entered. So 30,000. Now, if you look at the 1 to 10 centimeter range, there's approximately 1 million of those pieces. And those are tricky because they're a lot more difficult to track. Okay, so 1 million pieces out there that would do irrevocable harm. You cannot potentially, protect from those larger pieces, large enough to do damage, small enough to be difficultly tracked. And then beyond that, there's a small debris, and there's around 150 million pieces of those, and those are more modeled because you can't track them at all. So that just to give you the scope of what's out there, it seems, space is big. Right. And a lot of folks say that. But when concentrating these orbits, this can increase the potential risk for collisions between 2 defunct objects, or even a small defunct object that runs into an operational object.
anyone else care to help set the table here? Like, what is in the this particular range that ESA is speaking about, this 800 to 1400 kilometers? Why is that so significant? Why are they calling that out? Is that a range with Jeremy? Yeah.
Yes, sir. So I'll cut in here, maybe just to throw in a few thoughts. That said, I am a lawyer and not a space physicist. So when you've got a lawyer like talking about some of this stuff, you might have a problem. I did just also want to lead with kind of my standard disclaimer. While I am an Air Force JAG member, and while I am a professor here at the United States Air Force Academy, nothing that I say should be construed as the US government's official position or the position of the Department of the Air Force or the Air Force Academy itself. So with that lead in, so I believe that ESA probably selected this range because it's one of the sort of primary altitudes where a lot of our very valuable space systems, not just ours as in the United States, but ours kind of globally, are located, right? Whether these are telecommunications satellites, whether these are at least some of the GNSS system satellites, right, from various countries, whether that's Galileo, whether that's GPS. I believe that this range, right, that they've selected is to demonstrate that this is a widely used, very valuable kind of altitudinal range, which we would be concerned about having space debris, right, in that area. Now, to your previous question, Scott, about, right, the kind of nature of how this debris moves, again, not a space physicist, but as Christopher explained, right, as Charity explained, this debris is going to be up there for a very long time. We heard in the previous panel, right, about how space objects that are not refueled, right, are generally kind of in free fall. They're being acted upon by gravitational forces of, right, the bodies surrounding them. And so, right, much of this space debris would be being acted upon by the gravitational pull of the Earth, very, very slowly, right, drawing it back towards the Earth's atmosphere. That said, based on the size of the debris, right, as Charity pointed out, based on the height and the altitude of debris, this could be the process of possibly dozens of years, possibly hundreds, possibly more, right, depending on the altitude of some of this debris, which is why it's such a significant problem, because once you have significant amounts of debris in a particular area, especially if it's a higher LEO orbit, a MEO orbit, a GEO orbit, these are areas in which debris simply won't remove itself from the environment in a meaningfully fast period of time. It's a very, very lengthy process for that to naturally degrade and then enter back into the Earth's atmosphere.
Yeah, Scott, I'll just add from some points for folks that are tuning in that are more in the space law and policy realm than maybe closely following the altitudes that constellations, for example, are deploying at. And that's to note that, some of the major constellations that are being deployed or that are planned are in this range of altitudes. Specifically, SpaceX's Starlink is in the 550. I believe Kuiper is below that, around 370, 390 kind of range. And then OneWeb is planned for 1,200 kilometers. And if you look at the FCC's 5-year rule, for example, on orbital debris, which I'm guessing we may talk about a little bit, it, for example, is targeting 2,000 and below. So, this is an area that is, not just significant in terms of the existing activity, to Charity's point about 60 years of aerospace and orbital activities deploying through or around this, but also to the significant plans for various companies. And I just mentioned 3, but there are definitely more who are looking to participate in activities that will depend upon this area, these orbits.
So in the late 70s, this idea of the Kessler effect, Donald Kessler, who was a NASA scientist, laid out a study, and it details a particular effect that became known as the Kessler syndrome or the Kessler effect. And one of the big fears of the space community is this effect. And so from a commercial industry perspective, perhaps that may best highlight some of the direct effects and the considerations of cost and design or insurance and launching and materials. What are some of the tangible impacts on the realities of the space commerce industry? Are we are we just scheduling launches to hit the gaps, or are we changing materials now to withstand impact? So how pressing is this need to reduce orbital debris?
Aaron, I'll go. I would love to hear your answer about launches as well. Okay, so Kessler effect, a lot of folks out there think like one day things are all good and well in space, and then two objects collide and poof, we have no more space. We can't use it anymore. We can't take remote sensing. We can't do comms. That's not what the Kessler effect is about. The Kessler effect is sort of insidious. I call it like boiling a lobster, right? You put them in the cold water, it gets warmer. Okay, and suddenly it's a little warm, and then it's just too late to do anything about it. It's a slow, it's not the entirety of the orbits that would be trashed if a Kessler effect was started, but it just adds cost, it adds risk into space, and commercial operators don't like those two things, right? Adding costs to their bottom line and adding risk to their bottom line, because insurers and regulators and investors don't like risk either. So, or a lot of risk rather. So that's what the debris issue and how it's slowly growing is impacting commercial space operators. It's adding those small costs, but as things get more congested in orbit, we're adding more and more costs to how we operate in space. And in an era where costs should be going down, right? Because the access to orbits. So I think there are investments going on in like drag sails and interfaces for third-party removal. There are obviously a lot more folks that maybe do astrodynamics on teams for satellite operators. Maybe there weren't so many before. I think that's a booming degree to get astrodynamics. And then there's also regulatory costs, because I think regulators are starting to ask a lot more questions and demand more from applicants. And so that requires a whole bevy of lawyers to pour over data and technical managers as well to contribute to that application and make sure that regulators are comfortable in assessing the risk of these operators. So I don't have a number to put on, but the question, how it's asked, should we wait for a disaster? Or sorry, can we delay? Or, I don't think we should wait for a disaster to happen. What is the pressing urgent here is because we use data and we understand that things are getting warm, if you will, the lobster boiling analogy, things are getting warm. And so we're starting to pick this up as a community and want to do something to prevent it before it gets even more riskier in orbit.
Yeah, and I'm happy to jump in from more of a launch perspective, which is that, launch operators need space to be available to their customers to be able to launch, right? So if there are collisions or debris issues that diminish the opportunities for utilization of various orbits, and that means that there's a diminishment in the marketplace for launch as a result, the demand for launch, then that is a negative result there. Launch providers are moving in a direction of, of sustainability approaches. For example, the deorbit of second stages, so making sure they have reserve fuel. We certainly have learned lessons from old second stages, right, where we didn't depressurize, we didn't reduce the amount of fuel on board in such a way as to diminish the opportunity for explosions. Some of the debris that is in orbit is a result of second stage bodies that got to a certain point in their life and degraded to such that they had explosive events. So we certainly are thinking about that, and that is part of, to Charity's point, of the regulatory process of discussion with licensing vehicles. Is what is your demise? What is your plan for your second stage? Are you going to be moving it into a parking orbit? Are you going to be deorbiting it? What will that look like? So that is something that is a newer aspect of the discussion space, certainly one that is of interest. And then, ask questions about and plans for use of second stages. Can you repurpose a second stage on orbit? Could it be used for contributing to refueling efforts? Could it be used for, could it be, utilized for, transitions from, Earth's orbit to higher orbits? So I think there's a lot of innovation, also to Charity's point, in the launch side as well as in the in-space side, from companies like Scout, for example, that are looking at how do we understand what's happening between satellites so we can plan accordingly. Activities to make sure that we're doing really good collision analysis when we do launch, right? So can we make sure that we're going to safely launch to the orbit that we're trying to achieve for our customers, and then will our customer be able to safely deploy? So I think that, it is like, necessity is the mother of all invention. This is, I think, a situation like that. And it is important that we solve for these challenges before a Kessler-like situation where we have diminished the opportunities such that there are negative economic impacts that far surpass the economic cost of making changes to prevent that situation. I also think, and I would really appreciate hearing from Jeremy on this, because I think, we can talk about the commercial economic impact, but there certainly is a national security aspect to this that is really important.
Yeah, absolutely, Karen. And I was thinking about this as Karen and Charity were talking as well. I mean, obviously, our topic today, right, is the orbital economy. So national security is maybe playing a little bit second fiddle to some of the commercial interests in our particular discussion today. But Karen is absolutely right? The creation of space debris and the threat that it poses to these very valuable and important orbits is no less a national security threat than it is a threat, right, to commercial space interests and others. And this is one of the reasons why both the Department of Defense itself, as well as kind of the broader US national government, have kind of put forward this whole of government effort towards these developments of responsible behavior, right? And so 2 summers ago, for example, Secretary of Defense Lloyd Austin, right, published the Department of Defense's tenets of responsible behavior. One of those tenets was limiting the creation, right, of long-lived debris. And so that's something that DoD at least has been pushing forward very, very significantly, right? Those tenets of responsible behavior have now been incorporated into DoD directives, right? So it's not really an optional thing for us anymore. And you can also see, right, through kind of the public-private partnerships, the partnering that the Department of Defense and other government agencies have done with private enterprises, right, like SpaceX, Boeing, other government contractors, right, the United Launch Alliance, the ways in which we as, right, the government and the Department of Defense are trying to work with commercial partners to reduce our own economic footprint in the creation of this space debris. So 100% agree, right, with everything that Charity and Karen said, in addition to the fact that this is a critical national security issue as well.
And one thing I'll add that I was going to note in talking about the activities that occur at the orbits in this discussion space, referring back to the ESA comment, and then also this is human spaceflight, right? So, this is the area in which we currently conduct human spaceflight, and for which there are a lot of planned activities for commercial capabilities, and through which we will need to fly humans in order to get them to the moon, Mars, and beyond. So we want to kind of make sure that we include that very important activity in this discussion about why we need to be thoughtful about orbital debris.
I think that's a fantastic point. I'm glad that was raised, and to segue in a little bit to what Jeremy was saying with military uses and so on. Maybe if we could touch a little bit on ASAT testing and maybe what actually is that? What are the basic types and purposes? Is there a distinction or a meaningful distinction between uncontrolled and controlled? Maybe just kind of explore how that is, a big driver of space debris, or has been, if you don't mind.
Well, I can certainly start off just a little bit, which is to say that there's, I think that all anti-satellite tests are uncontrolled. and because when you look at the consequences and the effects of that, the cascading spreading out of debris cannot be predicted beforehand with any fidelity, and it cannot be controlled. I think the major distinction is not between controlled and uncontrolled, it's between destroying your own space object intentionally, and which is what we have seen, and the potential to destroy another state's space object, which we have not seen. I think that, so that's how I would describe it. And then the other major division is, direct ascent, which is a missile headed to space, versus something which is placed in the space domain, kind of like a space mine, to destroy something which is on orbit. I'll leave it there if there's any other comments though.
Sure, I can just jump in here. I would say that I largely agree with Chris with respect to the idea that it is very difficult, if not impossible, right, to control a kinetic ASAT test, right? And so I think that we tend to think about ASAT tests as inherently kinetic. There are a wide range of anti-satellite weapons, right? Some of which are kinetic and some of which perhaps are not. And so, right, the kinetic testing of, for example, like Chris mentioned, the direct descent missile, or the space mine, or maybe the co-orbital projectile, right, that is somehow, right, pumped towards, right, some other satellite. Those would all be examples of kinetic anti-satellite either testing or attack. And yes, I would generally agree that those are very difficult to control. Now, to play the devil's advocate, there have been arguments by certain countries, right? The Indian test in 2019, perhaps the United States Operation Burnt Frost, right, in 2008, that the trajectory of a certain kinetic missile targeting a satellite can matter, right? And so, for example, the United States at least argued for the Operation Burnt Frost that the kinetic weapon, kind of went up and over and struck down, right, when it struck its satellite target, blasting debris downwards into the Earth's atmosphere rather than upwards, right, into higher orbits where it could damage other satellites. Now, I think that there's, significant debate as to whether or not that's truly a controlled test or not too, and certainly some very, very good arguments that it still is not. So 100% agree that it's always an enormous risk, right, to engage in anti-satellite kinetic testing. But again, right, do remember that there are certain anti-satellite capabilities that are not necessarily kinetic, that could be electromagnetic, that could be, right, perhaps hacking attacks targeting the software that operates satellites. And of course, right, you could disable a satellite's capabilities by taking out its ground station terrestrially, which wouldn't involve any sort of, right, attack on a satellite itself. So just a couple of points kind of from a military perspective there.
So within the Outer Space Treaty, Article 9 creates this idea of referred to as the duty of due regard. What does that mean? What do we have any kind of clear indications, within the context of its reference within the Space Treaty? Can we dig a little bit at where that is really going to apply, and does this violate ASAT? Do ASAT tests violate that duty in any way?
Who wants to go first? So I'll take the first stab at it, because you saw me get up and walk over to get my copy of the treaties. It's not merely that we have that obligation of due regard, it's that we have all of Article 9. And, that due regard is found in the first sentence of Article 9, which also talks about the principle of cooperation and mutual assistance. And that, states shall be guided by the principle of cooperation and mutual assistance, and shall conduct all of their activities in outer space with due regard to the corresponding interests of other states. Those are the first sentence. The second sentence then goes on to say that states shall pursue studies and exploration of outer space so as to avoid their harmful contamination, and shall, where necessary, adopt appropriate measures for that purpose. So I'm not signaling just due regard abstracting it away from those other obligations, but to say that it exists in a treaty provision which is binding, that has a few, principles in it: cooperation, mutual assistance, due regard, and the prohibition on harmful contamination, and the obligation to adopt appropriate measures to prevent harmful contamination. So now, when we talk about those treaty provisions, there's two qualities I'd like to point out. One is that they are binding. They are binding on states as obligations to conduct a particular activity, show due regard, or as prohibitions to not do something to prevent harmful contamination. So they're binding, but at the same time, they are vague. So they're binding, yet they are vague. And the fact that they are vague does not alter the fact that they are binding. So I want to put all that out there to talk about, I do believe that the intentional creation of debris, whether it's your state space objects or another state space objects, would violate, in other words, not conform to, not observe that obligation of due regard. And there's a lot of there's plenty of rationales that underpin that. One is that when we have seen the creation of debris, there's outcry about it. There are states which make statements saying, we don't like this. We don't like that it happened. We think that it should not happen again. There's also states which, take national legislation and national legislative measures so that they don't do it, and they don't allow their commercial actors to do it. Some of these things we start to build up so we know kind of what due regard means. Now, due regard is not utmost regard or utter regard, and in fact, it shows some, component of it is that you can show some disregard to the actions of others. But certainly the creation of debris and despoiling the space domain, it is tough to make an argument that it conforms with all of those obligations that I mentioned. And when this goes back to what Professor Gruner was just speaking about, is that this, when we create debris on orbit and it spreads upwards and downwards, and it spreads, it creates kind of a circle around the globe, that is indiscriminate. And it is long lasting. Those two elements, indiscriminate and long lasting. That not only, I think, violates due regard principles, but those are requirements when we talk about international humanitarian law, the requirements of distinction, proportionality, necessity, and elements of humanity. And that we must conduct weapons testing to make sure that we don't violate those principles, and that our weapons do not cause indiscriminate effects. So if you destroy something and you create an explosion, which then spreads around the Earth in orbit and is long lasting, so that in the future, civil, commercial, military, other actors, third parties, neutral states, their spacecraft is flying through that piece of debris, that cloud of debris that you could not control. I believe that violates the requirements of distinction, if not proportionality, as you are creating indiscriminate effects with your weapons. So whether we are in peacetime, violating due regard, or striking an object and creating clouds of debris, violating IHL, I think it is not clear. I can't point to a treaty that says creation of debris is illegal, but when we put these elements together, I would like to think that I'm making a strong case for these things being violative of the law, if not in letter, then in spirit.
If I could just jump in with a brief point here, I think that Chris's analysis of Article 9 is certainly very apt, right? And I think that certainly from an academic perspective, Chris's point is a good one. I don't really know if there's a whole lot of wiggle room for arguing otherwise. That said, with respect to all of the ASAT testing that has currently gone on, right? So we talk about, for example, what the hard binding law is, right? And Chris gave us that from Article 9 of the Outer Space Treaty. But we also have, right, customs and interpretations of what the law is based on state action itself. And at least with respect to the last several rounds of ASAT tests, right? The Chinese test in 2007, Operation Frost in 2008, the Indian test in 2019, and most recently, right, the Russian test in fall of 2021, right? there really have not been, there's been a lot of outcry, right? Like Chris said, there's been a lot of condemnation. But I think out of all of those tests, only once has a country alleged that it was actually a treaty violation of the Outer Space Treaty. And I think that that country did not specify particularly what provision they believed was actually violated. So even though, right, you have this wide-ranging condemnation, what you don't necessarily have is persistent state practice interpreting an ASAT test as a violation of Article 9, which I think is to some degree important. Although, right, again, how you interpret, right, the binding provision, because as Chris noted, it really is binding, but it is also vague, as he noted. And, right, again, nobody has come out directly and accused Russia, China, India, the United States of violating Article 9 on the basis of those tests.
Thank you. Anyone want to add an opportunity to add? Okay, so in line with this, it was about a year ago, Vice President Harris, through the White House, announced that the United States is going to commit to not conduct destructive direct ascent anti-satellite missile testing. And I think the broader question is, well, will the world follow our lead? But what is the intended global significance of that commitment? Is this something more than symbolic? Are we going to head toward development of get some norms out of this?
I mean, I'm very happy that the U.S. has led on this. We are tracking what other states have made these unilateral political commitments. I see 13. United States was first, but was quickly followed by New Zealand, Canada, South Korea, Japan, Germany, the UK, Switzerland, Australia, France, Netherlands, Austria just a few days ago, and then Italy just last Thursday with another unilateral commitment that they would not be conducting, or they vow to not conduct anti-satellite tests, destructive anti-satellite tests. So that's not all the countries, and that's not even all the major spacefaring countries, but there is a growing, let's say, movement for these unilateral declarations. Will it be enough if they're just unilateral commitments by individual states? I leave that to the students to write articles on the binding nature, or how many states do we need before it is customary international law. But it is also matched by efforts at the UN level, UNGA resolution. I'm forgetting the name, the number for it, from last year. No, from 2021, that also vows to take a look at what is responsible behavior, and in defining what is responsible behavior, you're therefore defining what is irresponsible behavior. And I think that there will be a plurality of states, probably a majority of states, who will be able to agree that this type of intentional creation of debris is something that, if it is not clearly outlawed already, should be and will be outlawed. So it's a slow process, seeing states get their statements in order, but it is certainly welcome. And if we can take this particular activity off the table and proscribe it, then we can start looking at the other creation, the other debris creating problems.
Yeah, I'll just add, I was going to add the reference to the General Assembly, which approved, a resolution on this, that the work in the working group, the open-ended working group on space sustainability and reduction of space threats, right, which for which this is a topic of consideration. That the General Assembly's vote, mirrored that of the UN First Committees in terms of the those voting in favor versus those voting against, and what you saw in terms of the geopolitics represented there. And this has been a politicized issue, of course, at the UN. I'm not sure you can say UN and not have something that's politicized, but so be it. And as a topic that's between the US and Russia and allies there in particular. So as far as, behavior and norms are concerned, it does, we do seem to see slowly a developing consensus around the idea that ASAT testing should, that creates debris specifically is out of bounds. And, we'll see progress from there, perhaps on other kinds of ASAT testing, or we won't. Because the consensus around this really does seem to be consensus around debris and the debris creation, and aligned with conversations around sustainability and the long-term sustainability. So you see a lot of debris, anti-debris focused conversations versus conversations that are more focused on military activities in space, because we can all agree that less debris is better.
I'm seeing an emerging new space race based around norms of behavior. So the first to define, the first to implement, the first to bring a coalition along with them. I think this is a positive thing and could drive space sustainability faster than what it's been in the international multilateral forum.
And Charity, to that point, I also think it's an interesting point that we see companies like Astroscale that are multinational companies, right? And so I think the more to the point about the space economy and commercial activities, that also is an important part of this conversation. When you see companies that are operating in many countries, or for example, on the FCC side, right? Not only are US licensed entities subject to the FCC's debris rules, but anybody wanting to gain market access to the United States is subject to that. And my expectation, to Charity's point, is that we will see that same requirement levied against companies that are trying to operate or have landing rights or market access in other countries. And that certainly I think an important trend to follow.
As we approach our time here, I just want to include the third part, just as might be brief, but decommissioning. So the idea of pushing either satellites out to a graveyard orbit, or the idea of satellites burning up in the atmosphere. I remember watching the sky as a youth and seeing streaks in the nighttime sky and say, hey, what great celestial events going on. And now social media says, nah, it's just some space junk burning up in the atmosphere. So, what's going on in that area? I know the FCC has recently adopted a requirement within 5 years of decommissioning or deorbiting. But are these competing models?
Yeah, I'll jump in that. Go ahead, Charity, actually, please.
Sorry, I'll be quick. So I wanted to talk relative to that. Direct re-entry is the preferred method according to the orbital debris mitigation standard practices of NASA. And so depositing at end of life into the atmosphere is the norm today, but it doesn't have to be the norm tomorrow. We're building out on-orbit servicing capabilities that can reuse, recycle, and we should be thinking those 10, 20 years ahead. But right now, for the urgent problem, direct re-entry is what's happening.
Yeah, I'll add that, so, the FCC has moved out with its rule. There are discussions in other licensing agencies with regard to releasing regulations, and an interagency working group on, that's discussing orbital debris policy. Something I've advocated for in the past is, whole of government approach. So making sure that we have something that, many companies are not just licensed by one entity within the US government's space regulatory regime. And so having an approach that covers all of those activities in a transparent and uniform manner would certainly be helpful, as well as flexibility. To Charity's point, what's the norm today because of the technology and capabilities that we have may not be the norm in the future. And so making sure that we are promoting innovation and technological advancements, and that those are going to be able to will fulfill obligations and requirements in the future is really important.
I would also just note on that particular question, there are an increasing number of both state governments and then also private entities that are wanting to do more and more in farther reaches of cislunar space. And so when you think about this idea of graveyard orbits, right? What is a graveyard today might be a very, very valuable orbit, right? 10 years down the line, 20 years down the line. And if you fill that orbit with junk now, because it's a graveyard, right, that's going to have knock-on effects using cislunar space in the future, right? And so again, I think to Charity's point and to Karen's point, this issue of figuring out what you need to do, what the best thing to do with this debris is, or with deorbiting, all right, kind of an end-of-life system, pushing it out into deeper space may seem like a solution now, but likely will have additional consequences as we continue farther out into space and find useful uses for those farther orbits.
That essentially concludes our time. Final words from each of you, if you should have one, and if not, that's fine too.
I'll just note, Scott, I just realized that I should have said this at the very beginning. I am here on my own behalf as a professor adjunct at Georgetown, not on behalf of Relativity, for whom I'm now a consultant as opposed to a full-time employee. So very happy to speak to all of these issues, but want to take note that if anybody is giving any kind of association with my remarks, I'm happy to associate them with myself, and appreciate the opportunity to clarify. Thank you.
Yeah, I'll just jump in and say thank you to Mark, right, for the invitation to appear on this panel. I really, really appreciate, right, the ability to talk with you all today. And it's an honor, right, to share this panel, right, with such distinguished experts as Chris and Karen and Charity. Thank you guys for, right, participating as well. And thank you, Scott, right, for moderating. It's been an honor to be here, and I'm really, really thrilled that I was able to participate in this around my academy classes. Thanks.
Seconded.
I guess I'll wrap it up by saying thank you again for the invite, and really encourage everyone who's online and listening today to continue this conversation. We need your help. This is a really, they call super wicked problem, a lot of layers involved. There's anything you like about technology, policy, business, it's all there. So continue advocating and learning about the space debris issue. Thank you.
And with that, thank you all. It's truly appreciated. And with that, I will pass the mantle, which I believe means if you could all turn off your video and mute, and that will do it. Thank you all.
Thank you, Scott. Very well done. What a terrific discussion. We are flying through the program, and I'm having a terrific time, and I hope that everyone else is enjoying it as much as I am. I have the pleasure now of introducing the fifth and final panel of the afternoon, and this is the panel regarding liability, insurance, and dispute resolution. And I went down a dark path with respect to interoperability, and this is another darkness that comes with the expanded commercialization of the orbits and the increased number of players and the traffic congestion. There will be collisions, there will be interference, there will be disputes, but how and when does liability arise? It's not clear under international law. How should disputes be mediated? How should they be resolved? Are space law disputes different from other types of disputes, that is space-related disputes between operators in orbit? Are there special dispute resolution mechanisms that are required? These are the questions that we're going to jump into right now, but I want to introduce our panelists, who I'm very excited to move forward with this panel, because some of the panelists I know personally and expect great things from, and some of them I know from reputation and expect great things from. So I'm excited to see what comes of this. And let me introduce in alphabetical order, Andrea Harrington, Professor Andrea Harrington. Is it Professor Doctor? It may be, but certainly Professor Andrea Harrington of Air University, who wrote a book, very good book recently on space insurance. And so we welcome her expertise. Thank you for being here, Andrea. Chris Hersey. Chris is he is a long career in the field of space law and policy, and has been an inspiration and a friend to me for quite some time, and now is at the head of the Space Court Foundation, which is a very aggressive venture to collect all of the thoughts and materials on space law to enable the ease of dispute resolution, in addition to legal compliance. Chris Kunstetter, wonderful to have you here, Chris. I worked on the pleasure of working on the ComStack with Chris years ago, and arguably he's the leading, the thought leader in the field of space insurance, and is associated with XL Insurance. So thank you for being here, Chris. And finally, last but not least, we have a visitor from a foreign land, all the way from Mexico City. We have Laura Zielinski. And Laura is notable and grabbed my attention by her work in the arbitration of space-related disputes. So she has really shown initiative to systematize and collect the history of space-related disputes. And so we're very fortunate to have her here from the law firm of Holland and Knight. So welcome everyone. I'm going to kick this off with a reference to the first panel, and to try to bring us full circle. We heard about the specter or the grandeur of mega constellations, something we haven't seen before. They bring great congestion and threat of collisions and interference. What has been the response of the insurance community to these changes, these massive changes in the space industry? And I think I'll ask Chris first, but also Andrea to comment on this.
Thanks, Mark. And let me be the probably 25th person today to wish you a happy birthday. And it's great to be here. You know, we've been insuring, there's been space insurance for almost 60 years. And I've been in the business for the majority of that time. And we have been insuring constellations since the original Iridium, since the original Orbcom, Globalstar, back in the late 90s. So constellations aren't new to us. What's changed is obviously the size of the constellations, but also the fact that the operators are very aware of the fact that they need to be very careful driving their satellites through space. So we're pretty calm about most satellite operators, the Starlinks, the OneWebs, and such. We do ask them when we're doing our insurance underwriting. We ask them what their plans are for collision avoidance, for that sort of thing. So, and we have, come across a few, shall we say, rogue actors who have less concern for others than they should. But basically, it's I think everyone wants to be able to use space. And so nobody's going to do anything intentional among the owner operators. Nobody's going to do anything intentional to mess that up. So that's I don't know if that answers the question, but throw out some ideas.
Andrea?
Sure. So I'm jumping in from a more kind of theoretical and academic perspective.
than Chris, who does this every day. And I'll give the same disclaimer before I
That's
start.
okay. That's okay from my perspective.
I'll give the same disclaimer before I start as Jeremy did on the last panel, which is to say I'm here representing myself as an academic. My views do not reflect the views of the US government, US Space Force, US Air Force, any other part of the government. So the first thing I want to say is that there have been changes in the space insurance industry, and it's been a rapidly adapting insurance industry over time. We see the industry now grappling not only with questions of what you call mega constellations, and I think the companies that are generating these constellations don't always like the term mega constellations being applied to them. But if you think about with the context of suborbital human spaceflight, space tourism, space tourists being brought to orbital stations, starting with the ISS, but of course, in the future, we expect that to expand. And as we look forward to commercial lunar operations. And so the insurance industry needs to adapt to all of these ongoing changes. The good news story, at least from the ease of adaptation and changes, is that there are a few insurers in the global market that supply really the vast majority of space insurance, because it is such a specialized type of insurance, and of course is very high risk, that therefore, you know, the folks who are underwriting this kind of insurance need to really understand the risks that they're undertaking. When you're looking at more traditional forms of insurance, you know, think about your car insurance. There's a law of large numbers there where there's a predictability of what that loss in the market is going to look like over time, and you can balance that out. But when you're talking about something like putting mega constellations in orbit, it's not as easy from an actuarial perspective to calculate, because you don't have that law of large numbers, you don't have that history. And so this small number of insurers has really designed their business model around being able to understand these risks and cooperatively work with the industry to understand the risks, to be able to provide that insurance. And when we talk about insurance, we kind of just mentioned space insurance broadly, but I just want to take a moment to separate out first party and third party liability, because when you don't have a conversation about insurance very often, you're not necessarily thinking about the difference. So first party liability is, I launch a satellite into orbit and I buy insurance on my satellite so that if something happens to my satellite and I can't use it and I can't get the value from it, then that satellite can get replaced, right? Think of it like the comprehensive coverage on your car. If something happens to your car can get replaced. I'm the one party, right? I'm first party. Third party is, my object does damage to somebody completely unrelated's object, right? Completely different entity, have nothing to do with them, just happen to be in the wrong place at the wrong time, right? When you crash your car together with somebody else's car, the insurance coverage for hitting the other person's car is that third party. So when you're talking about space and you're talking about what is mandatory in many individual countries' domestic law, what you're really looking at is that third party insurance, not that first party insurance, though that first party insurance is still critical to the financial viability of many of these space companies, depending on, you know, how many assets they have. If you're talking about a mega constellation, less so, because they build in, you know, a 10% loss of those satellites is a good thing, right? Whereas if you have a smaller number of satellites, they're more expensive, they're more exquisite. It can be a much more significant loss to the company if one of those assets is malfunctioning or destroyed in the process of getting it there. But we shouldn't just think about space insurance, you know, as one blanket term. I think we really need to contemplate that there is a difference and a distinction between the first party insurance that protects the financial viability of the companies that are engaging in these high risk activities versus the third party insurance that is what you're talking about with dispute resolution that might come into play because somebody has caused damage to somebody else. And how do we get indemnified for that damage if we have to pay out, you know, is insurance going to pay that, et cetera, et cetera. But I think that even though mega constellations in particular might be a new problem, it's not really a truly new problem from the space insurance industry's perspective. It's just an evolution of an existing set of insurance policies and insurance problems that they've been dealing with.
Yes, excellent. And thanks for helping set the stage, Dr. Harrington. And I guess I want to add to that by explaining to the audience that there's a requirement under US law, if you're going to launch a rocket, that you acquire insurance that will cover the maximum probable loss to third parties. And so insurance is a requirement of launch licenses. And so that's why we're discussing this, or one of the reasons we're discussing it. Now, in order to, one of the questions about insurance, this insurance requirement, is how to calculate what is required. This idea of maximum probable loss. And for many years, as I remember, maybe Chris will recall this from our days in the ComStack, was that it was very much a back of the envelope kind of calculation, and was done without really deep and modern analysis of the actual potential harm caused by rockets. And with the advent of new technologies to develop and understand these risks, the calculation of maximum probable loss should also develop, so that we're not asking companies to buy much more insurance than they actually need, because these premiums can be costly. So that's one of the questions I have out there, but I'd precede it with this one, as I'm personally curious about that. The launch cadence has increased significantly. We are just flying many more rockets than we have in the past, and that is going to continue to go up. So my understanding of the insurance industry, which is microscopic, but the more you can spread the risk, the cheaper the premium should become. Has that been the case?
I'll jump in and address that one. You know, we look at allocating our capital on a per event basis, excuse me, so per launch or per satellite up in orbit. So the more launches you have, the more failures you're going to have. Yes, there's the reliability, increased reliability of some rockets, but when you introduce new rockets, they tend to be more risky. So I'd say that the volume of business has not really brought down the price of insurance. What's brought down the price of insurance are several dynamics. One is cheaper launches. So whether it's new small launch vehicles or SpaceX lowering the price of their launches below the legacy systems. Smaller satellites with smaller values means more competitive pressure among insurers when we allocate our capital on a per risk basis. So those combined with just a softer insurance market in general in the last really 10 years or so has driven down pricing pretty significantly. And prices in space insurance don't rise unless capital pulls out of the market. So if insurance companies stay in the market, nobody really wants to be the one to pull out, because it's a good profitable business when it's profitable. So what's happened in the last 3 years is 6 major insurance companies have pulled out of the space insurance business because it's just not core to their traditional business, which leaves a few of us large companies, but a lot of smaller specialty insurers who specialize in space insurance. Going back to this issue of the MPL, it's actually a very, very timely issue, because the FAA has started a new advisory committee called the acronym is SPARC. It's Space Aerospace Rulemaking Committee, something like that. Anyway, they're standing that up, and they've asked me and some other insurance people, as well as industry people, to be part of it. And it's we have a 6-month window to come up with a report. When it comes to MPLs, I wouldn't say that they were done arbitrarily. In the past, they weren't. It was quite an analytical process. But what's changed in front of them and has made their job harder is we have new propellants, new systems, new technologies, new safety issues, new destruct mechanisms and things like that. So the technology has changed while they've been doing MPLs and doing MPLs quite adequately, but they recognize they need to revise Part 440, the financial responsibility for licensed launch activities rules. So that's a process that's actually just getting started up. First meeting is May 1st.
Interesting. Well, that is the latest, greatest news. I appreciate that insight. Very good. I have another insurance question. And that is, it's quite different. It's not the launch insurance, but insurance for our, high value, high worth people that have decided to become space tourists. And they want to fly with Virgin Galactic, for example, up into suborbital space. And but they're concerned that should something happen, some anomaly, some mishap, that they will die. And so I imagine they're looking for some kind of insurance to cover that possibility. And these are people that can generate a great deal of income, you imagine, through their remaining years. Are you in that market, Chris? And Andrea, what do you think of that? And I don't mean to exclude our other panelists, but their time is coming, believe me.
And from our point of view, we've been insuring human space flight for a long time. We've been insuring, going back to what Andrea was explaining before about first party and third party liability. We've been insuring human space flight missions, not for the life of the participants, but for the success or failure of the mission, which could include fatalities. The issue for us is that it's really hard to know ahead of time. Say someone goes up on a suborbital flight and they're getting out of the capsule after this exciting ride, and they bump their head on the doorway of the capsule. 3 weeks later, they get a really bad headache and they go to the doctor and they have, some issue. Okay, well, is that tied to that human space flight? Was it caused by, or, resulting from, or was it just some existing issue? That's one issue. The other issues really are quantification, and people talk about informed consent, signing informed consent, documents and things like that. But the heirs and estates of someone, their rights can't be waived by the person signing a waiver. I'm going to hand it over to Andrea because I'm quickly getting out of my depth here. But basically, the heirs and estates of someone who dies in a space accident, they don't have to hold to the fact that that person might have signed a waiver.
Yeah. And this, for the benefit of our audience, that is the model for suborbital spaceflight. It's one of informed consent, where you are told by Virgin Galactic or Blue Origin that your participation in the suborbital flight may very well result in your injury or death. And then you're asked to sign a waiver. Whether those waivers will stand up in court, we have yet to see. But that's the question. And then, of course, there will be an interest in these insurance policies by the flight participants. So, Andrea, what can you tell us?
So the waivers, where the spaceflight participant gets to provide that waiver to the operator for any liability, that's currently built into our domestic law in the United States through 2025. That sunsets in 2025, unless it's renewed by Congress, which it may be. But spaceflight participants had been excluded from those waivers, and then were added into those waivers through 2025. So you'll see on the books of some individual states, US states, not different country states, but states within the United States, that they have laws to encourage suborbital space flight companies to come to their states by offering those waivers, saying that you won't have liability for your space flight participants, and they can waive that, so that if the law does sunset in 2025, then companies may still be able to go to those states to seek the protection of those waivers. As the industry matures, and as those opportunities for waivers for spaceflight participants go away, and we say, okay, now you're going to be responsible for the well-being of the passengers on your spacecraft, space industry, much like the airline industry is responsible for the well-being of the passengers on air carriers, you are likely to see a transition that will occur, much like what developed through the aviation industry, starting with a limited liability where you or your family, in the case of your death, can recover up to a certain amount. And then beyond that, right, once the industry is mature, much like the aviation industry had matured, we went from that Warsaw Convention model with the limit of liability to getting rid of those liability caps under the Montreal Convention. As we watched, aircraft become much, much safer over the years, aircraft accidents become much less likely. And so I anticipate that the insurance industry will adapt in the same kind of way, where they're providing that insurance directly to the participants in the case of the flights when there is a liability waiver, because of course your regular old life insurance is going to exclude something like participating in a space flight. So you can't just be covered by your regular life insurance. You'd have to get an additional insurance policy specifically for your space flight in order to be insured for that. Moving from that model to then, once we have a more regularized space industry like aviation, where the carriers, right, the operators will then carry insurance for the payments that they would have to pay out when those waivers are no longer allowed to be in play, right, when they have to take responsibility for any injury or death of those passengers.
Interesting. I remember the days, although the memory is becoming foggy, when you could, there was a little kiosk before you got on an airplane, and you could buy the traveler's insurance before you got on the airplane. And, we're seeing the same sort of concern, and we'll see what happens there. Okay, well, excellent work by our insurance specialists. I'm going to come back to you. Please don't log off. But let's talk more broadly about potential, liability and dispute resolution. And I guess I will set the stage by by saying that, let's imagine a U.S. telecommunications company is struck by a defunct Russian satellite. What can that private operator do? Is there any potential grounds for liability? And then if there are grounds for liability, what is the process for actually taking it to court? And then so that would be an example of a dispute between a private entity and a sovereign entity. But now with the privatization of low Earth orbit, it's more likely that we'll have collisions or somehow some kind of interference between private operators. What can we expect from that, and what are the available procedures for seeking compensation? And I guess let me start off with Laura and go to Chris.
Yes, so happy birthday and thank you for inviting me. So under international space law, we have the Liability Convention. So states are responsible for damage caused by their space objects. So in case you are being struck by a space object being launched by a state, and that object can be attributed to the state, a private operator in theory could have a claim against that state, not directly, but through diplomatic protection through its own state. So any dispute under the Liability Convention for liability and for damages caused by space objects in space would be state-to-state disputes. The Liability Convention also contains a dispute settlement mechanism called the Claims Commission, which at first view sounds great. It looks a bit like an arbitral tribunal, but it has two important downsides because its decisions are only binding if both states agree. So you would have have the state that lost the proceeding to agree that it would follow the decision. And as I mentioned, I mean, it's only open to states, and if private operators want to use it, they need to ask for diplomatic protection. So they need to ask a state to defend their interests under international law with regard to another state. And then I have solutions for that, but I will let Chris reply first.
I appreciate you setting that groundwork. We have the Liability Convention, which exactly set out the standards for fault for space operations. And if your space objects causes harm, causes damage on the surface of the Earth, if it falls on your car or your grandmother's house, God forbid it, the launching state will be strictly liable. It's an ultra hazardous activity, so it fits that strict liability construct. If there's damage between space objects in orbit or beyond, then you have to prove fault.
Yes,
that's a problematic issue, and I'd like to pursue that as well.
Yeah, Chris.
But Chris, go ahead and give us your opening thoughts.
Yeah, there's a lot of threads here, and especially since we have students on the line, I think it's important to really start at a base level that we understand, right? So we have all different types of courts, and when you look at the level of national activities, commercial activities that are inviting novel space activities, whether it is debris removal, whether it's orbital transfer vehicles, whether it's the gas stations in low Earth orbit. There's going to be a lot of things going on with those types of technologies. It's not just whether or not you smack into something, but it's also going to extend to areas of patent law, secured transactions, contracts. You might even have labor disputes if you're on a commercial habitat. So these are the types of claims that courts generally receive from litigants. And it happens at an international level, as Laura pointed out. It happens at a national level, and it happens in these private arbitration type of courts. And I think what's interesting is that this is definitely an area ripe for more consideration and research, because you have a lot of things going on here. You have a lot of different treaties, bilateral, multilateral treaties that get into patent law, industrial property, ownership of different types of space objects, and they may go to different types of courts. And, as you pointed out, Mark, looking at the disposition of the litigants, what is their nationality? What are they, a private entity or government entity? And that will tell you which court is you likely will go to. So then it really gets into what are the claims and what are the rules that will be governing these claims. And so you have the Permanent Court of Arbitration about 12 years ago established some rules. And they generally, and all these extra rules generally look at technical definitions, the types of evidence that can be introduced, the expertise of both the orbital judges and the experts that testify. And there's a lot of other considerations. And, I think what's interesting is that as we do more specialized novel activities, it's going to necessitate a lot of different types of litigation. One example that I'll proffer, which I don't think I've ever really heard anyone really talk about that I've been thinking about for some time, is the distinguishing between airports, maritime ports, and space ports. And then you have this little thing over here that got brought up already, that launching things into space is not an export. So there are no ports in space, and port has a very particular connotation and carries a lot of additional rules. You think about going to the airport, the level of security. Well, astronauts aren't going through metal detectors, as they get on the plane, get on the launch vehicle, so to speak. But it does invite potential subterfuge in some of the rules that we take for granted here on Earth that could be going on in space, that could include infringement on patents and industrial processes. And the one thing that could be a consideration is that you have defenses under the Paris Convention, which deals with the protection of industrial property. And they have this temporary presence defense that basically says if you have this temporary presence as you go through a national territory, you could have a defense against infringement on patents. Well, imagine all the different national things that could happen on the moon or in low Earth orbit, from pharmaceuticals. You could have IP infringement. So all of these types of things could come into play, but you haven't seen that yet, because traditionally, as I'm sure Chris and Laura and Andrea are well aware, there is this base assumption where you knock into things. And but a lot of litigation in space, when it comes to space, depending on how you want to define it, center around secure transaction issues, contractual issues, who gets ownership of what, and there are rules out there like the Space Assets Protocol that was formulated by UNIDROIT with respect to secure transactions, different types of rules. How do you take possession of these things? How do you transfer when you have export control considerations? So I just want to say to the students, you're looking for paper ideas. There's a ton of stuff here that's going on, and there's a ton of novel things that are being proposed and currently in development. And as soon as the ISS goes away, you were going to be in a real different realm of law. And so I would expect at some level litigation to increase, and you will see it. So then the point is, where do you want litigants to go? And in many cases, as Laura's pointed out, if you're dealing with a sovereign, you may not be able to avail yourselves of certain international courts. It doesn't mean that your home government couldn't work to get a mixed arbitration panel together. So there's a lot of different options that are out there, but I think it's still an open question to when are we going to have this breaking point in activities that you would see this level of litigation and the necessity for these rules.
If I may add to that, going back to the scenario where we would have a collision involving private operators. So in that scenario, the dispute resolution mechanism is a bit unclear because, as I mentioned, under international space law, there's no mechanism really available to international operators. They could agree to arbitration, but otherwise, for example, they would need to go to domestic courts. So we could imagine domestic litigation over a collision scenario. But in domestic courts, private operators might face issues like languages, bias, and especially sovereign immunity if the defendant would be a public entity. But interestingly, in 1998, the International Law Association proposed a convention on the settlement of disputes related to space activities. And one of the objectives they had at that moment was to provide a forum that would allow private operators to solve these kind of disputes. Unfortunately, it hasn't received enough political support, so it still hasn't entered into force, but there's a clear vacuum of dispute resolution mechanisms for private operators in space for pure space scenarios like collisions. And building on what Chris has said, if you have ideas for papers or something that could be put into practice, this is a very interesting area. But the reason why I interrupted is I think it's not in the future that we will see disputes. We already see a lot of space-related disputes, but I think we need to distinguish between pure space disputes. So, for example, concerning collisions that haven't materialized very much yet, but what we do see a lot is contractual disputes related to the space sector, because like any other industry, the space sector is based on contracts. So when a satellite is being launched, it is first manufactured, transported, operated, sold, whatever. So there are a lot of contracts in place. And most of these contracts, interestingly, contain arbitration clauses. And we have already seen quite a few commercial contractual arbitration proceedings. And I think with the increase in activities in space and with the mega constellation and all of the issues that arise from that, we will see more in the very near future. I mean, that's at least my understanding based on my own research and conversations I had with space companies. I don't know if you disagree. I think intellectual property issues and probably also disputes over ownership of space resources might be a bit further away because those activities are just starting, but I think there are already a lot of space disputes
Well,
as we speak.
thank you for mentioning that. And I have to take this opportunity to alert the world that Laura and her, the Space Arbitration Association, which she has founded, has on its website compiled information about known space disputes and how they were resolved. One of the problems, though, is that you know, most of them are conducted through arbitration, which is confidential. So it's difficult to, you know, derive principles from secret arbitrations. But she's done very good work on that point. Let me move to the Permanent Court of Arbitration, which I believe Chris mentioned. The Permanent Court of Arbitration years ago, I think it's been a decade or more, adopted special optional rules for space-related disputes. And Permanent Court of Arbitration is an arbitral institution in the Netherlands. So they developed, with the help of experts, some of which were on our in our symposium today, developed these special rules of arbitration. And from what I understand, they have not been used very frequently, although I don't know if we can really know whether or not they've been used. And I guess my question to the panelists, and I don't mean to silence our insurance experts because they are exposed, of course, by the nature of their work to disputes. Do we need special rules for space-related disputes? What is unusual about space?
If
You can go. All right. I'll go.
Go for it.
I think there are a lot of different unique scenarios that we haven't truly contemplated, and that we've gained from experience, especially with satellites, understanding, you know, the level of detail that you need to really to present in a court, admissible evidence, you know, finding the right experts to talk about why, you know, your side should win this case. They're useful tools for lawyers, for at least those who litigate. And the alternative, though, is, and this is sort of what I was alluding to in my what I was saying earlier, was you worry about form shopping, you worry about a court being able to handle certain types of claims. You know, for a long time until I believe it was the 2015 and 2018, when there was basic federal preemption on the issue of liability under the FAA launch license regime. You know, states had, the informed consent regime was split between 50 different states. And so there's been some, let's say, consolidation for let's say judicial economy, which is really important, especially if you are in litigation, you want to keep your court costs down. And that's another reason why you'd also do arbitration versus national courts, because you don't want to draw the wrong judge. You don't want certain technical things going to a jury, but then you may want to. It really depends on your, and I'm sure Laura can speak better than I do, having never litigated, but, you know, it really depends on what your client needs and what the facts and law bear out. But these are options that any client or litigant have, and they have to make these choices. And sometimes it's hard to decide what to do, especially if witnesses are in different countries. And as Laura mentioned, you have people that, you know, the documents might be in different languages. The international nature of space activities could complicate things, including whether or not you can even present evidence, because it could be export controlled. So these are the types of things that usually don't happen generally in other courts, that require a high level of expertise to be able to adjudicate claims. And so, you know, generally for economy, when governments, you know, like the United States, creates admiralty courts to handle those types of things. And so it is with intent that Nathan Johnson and I founded the Space Court Foundation to ironically and absurdly, but also looking forward in time, who's going to handle these things? Do you want, you know, all due respect to the to the judicial system of Alabama, but do you want a local magistrate judge handling a technical space law issue? And, or do you want the ICJ doing that? Or do you want an arbitration court handling that? So I think everyone's going to have different needs and expectations on whether or not you get those claims in the door to the court, assuming you have standing. So I think there's a lot of considerations here, and the special rules help not only the court, but the litigants and their lawyers to formulate an appropriate strategy to get a resolution. And that's ultimately what the whole point of all this is: peaceful dispute resolution. So we're not fighting wars in space.
Thank you. Yeah, Laura, I wonder, have you in your practice used the optional rules from the PCA?
No, but I just wanted to maybe present a slightly different point of view on the question, because I think some of the points that Chris mentioned are the reason why a lot of space companies prefer arbitration over domestic litigation, because space activities tend to be international, very technical, and also often very confidential because of the export control regulation, for example. And in arbitration, you can choose your own arbitrator. You can adapt the schedule to your needs if you need a decision sooner rather than later. You can agree on an enhanced level of confidentiality, and you can make sure that whatever arbitrators you choose are really experts in space technology. So you can make sure that whoever is deciding the dispute actually knows what they're talking about, which with a domestic judge that you cannot choose might not always be the case, whether in Alabama or in any other country probably. And so I would say that in general, all of the arbitration rules that we have, for example, of the Paris Court of Arbitration of the International Chamber of Commerce, which I understand is the those rules are the most used by space companies. I think all of them can be adapted to what space companies need. What distinguishes the rules prepared by the Permanent Court of Arbitration is that they thought about what is it that makes space disputes different from other disputes, and how can we adapt the arbitration rules that we use in any other dispute so that they work better for the space industry. And for example, they included rules that would allow the parties to present non-technical documents to the arbitrator. So in case your arbitrator is, or one of your arbitrators might not be the best space expert, there's a mechanism to make it easier for him or her to understand what's at stake. And there are also special rules of confidentiality to cater to the space industry. I think they would be very useful. My understanding is that they haven't been used yet because there's a time that is needed between when companies become aware of new rules, include them in their contracts, and then until those contracts give rise to disputes and actually become arbitration proceedings, it takes a certain amount of time. So now 12 years have passed since these rules have been published. So it might be the case that with the increase of disputes we are observing, we might also see disputes arbitrated under those rules. But I also heard that because a lot of the space contracts contain ICC arbitration clauses, and if you negotiate a contract, you don't want to use leverage you have to change an arbitration clause, which might not be that important to you. So that's why I think there's also some resistance to changing. So they just prefer to go with whatever they've been doing since they started, and don't necessarily want to change the rules. But maybe they'll become aware of those advantages and start using them, or maybe not. But sorry, you asked another question and now I forgot what it was. So if you want to ask it.
I don't know. What I'm thinking of right now is that you and Chris should connect. I see great synergy.
We've met already.
Yes, okay, good. I'm glad. And I know that Chris and Andrea have as well, with Chris writing the complimentary review of Andrea's great book. But let me, I think at this point, I did have other questions about private investment treaties, but we're coming towards the end now of our session. So I'm going to turn now to our insurance experts again. And do you see new markets of insurance opening up with all these new segments of the industry that didn't exist before? And how is the industry responding?
It's a good question. In terms of the products we offer, the insurance policies we write are what's called all risks policies. So everything is covered unless it's explicitly excluded. So we exclude war, terrorism, nuclear, anti-satellite, but everything else is covered. So collision is covered, solar activity, space weather is covered, internal breakdown of some component of the satellite is covered. Everything is covered unless it's something that's that's listed in the exclusions. That being said, we are looking hard at two new types of insurance. One is insurance for war risks, because we do expect that there will be conflict in space that causes damage to commercial assets. It wouldn't necessarily be a straight right back of the exclusions the way it's done in aviation hull insurance, but we're looking at various ways to try and design coverage. And it's an interesting topic and not one that's easily done. You have issues of attribution of a loss and intent and that sort of thing. And then the other kind is the other new type of insurance we're looking at is disposal insurance for active debris removal. If there's a way to kickstart the ADR industry by offering an insurance product that offers some insurance coverage to help with the expenses of active debris removal, we're working with one of the companies that's involved in ADR to develop a product for that specific thing. So yeah, I mean, always something new in space, and excuse me, and we're certainly we're trying to be as innovative as we can because we're trying to keep up with the industry.
Yeah, any thoughts, Andrea? Thank you. Any thoughts?
First of all, Chris, you hit one of my favorite points of acronym confusion, right? Because when we're talking to space people, ADR, active debris removal, everybody knows what that is. When you're talking about dispute resolution, though, which is also part of this panel, people hear ADR and they think
that confused me. You're right. Yeah.
So I always find that one amusing. Personally, one area that I'm really interested in seeing how it would develop, and Chris, I'm sure we can continue this having this conversation because I haven't asked you this question before, but is how insurance for the space resource industry would work, whether you're talking about lunar space resource recovery or asteroid space resource recovery, and what the differences might be in ensuring different types of space resource recovery, and if it depends how those are going to be used or who they're going to be sold to. There's potential political risk there, so if there's a political risk insurance element of that project, that's something that I think could be really quite potentially interesting as we move forward with different types of space activities in the future. And that's one that I have not yet heard come across. One comment that I wanted to make kind of overall listening to this discussion is something that I always try to tell my students, right? We hear there's this uptick in disputes, and we're talking about our contracts and our clauses for dispute resolution, but really the best thing that we can do for our clients as lawyers, whether we're in-house or whether we're in a law firm, is have really tight contracts, right? Think about the worst case scenarios. We obviously hope everything goes well. We expect everything to go well, but you're prepared for when things are going to go wrong, and you've thought it all the way through. And whether you're talking about your insurance contract, whether you're talking about your launch contract, whether you're talking about a contract for a joint venture partnership on a particular mission, that you really have thought through who is going to bear liability for what in what kind of scenarios, because that takes the pressure off then the dispute resolution process, right? The fewer incidents that have to go to dispute resolution, the better for everybody involved, particularly where dispute resolution costs money, right? Dispute resolution is not free. So if we can have a contract that is tight enough up front that can handle these potential abnormalities in the process if they occur and damage occurs or the mission's unsuccessful, then at the end of the day, everything in the industry is going to move along more smoothly.
Beautiful. We're coming to the end of our time, but out of respect for our audience, there was one question that came forward, and it's basically, is there a particular existing insurance industry that you all look to as analogous to space and draw inspiration from?
You know, there are aspects of different lines of insurance that are similar to space insurance. So people often bring up insurance of nuclear facilities, right? Very low frequency, but high severity of loss if there is one. But there are a lot of things that are different. Nuclear insurance is much more of a public policy. You know, there's a nexus with public policy. Aviation is where space insurance started through the aviation insurance market. So there are parallels there. There was actually a very good article that Tanya Masson-Zvan wrote recently about whether space insurance or aviation insurance should be the basis of human spaceflight. Okay, there you go, Mark. You've been reading, you know, space insurance. It has just unique aspects to it. We're dealing with for the vast majority of the insurance we do, it is the first party asset insurance, and the rocket doesn't know where it's going, and the satellite doesn't know what it's doing. It's just they're designed to do what they're designed to do. So we've even tried to look at other lines of insurance to expand our footprint. You know, other lines of insurance that are similarly low frequency and high severity. And our AXA XL does a lot of, you know, exotic lines of insurance and things like that. But we often try to get people off the idea that it should work like aviation insurance or it should work like nuclear insurance.
Yeah, I tell my students, beware of analogies. They're seductive. You think that you have a model to follow, but it could lead you down the wrong path because there are differences. So with that, I want to thank you all, Chris, Laura, Chris Gunstetter, Andrea, Dr. Harrington. Thank you all for helping finish the symposium on a high note with great style. I appreciate your participation. I'll ask you to shut off your cameras, and I'm going to deliver the closing remarks, and we will be done for the day. And I want to start them off by thanking all of our attendees for joining us. The whole purpose of this venture was to spread information and awareness about space law and policy and the very interesting place that we are in right now, but also to provide a platform to brainstorm among experts. And I do feel like we moved the ball down the field a little bit, or at least enlightened one another. That will help us move the ball down the field in the coming years. What did I learn? I mean, we learned so much about, you know, just the issues that need attention, the nature of current initiatives that are underway to address these perspectives from industry and government and other stakeholders, the special nature of space disputes that we just heard, and I was skeptical, I say, about the need for special rules, but I think I'm convinced now that we do need special rules for space disputes. And then I say personally, my favorite moment was a comment made by Chris Johnson about the fact that 14 countries have seconded the announcement by the US government that we will not be pursuing kinetic anti-satellite tests. I had hoped that movement had grown, and it sounds like it has. So that is something to celebrate on this International Human Spaceflight Day. Before I adjourn this meeting, I want to thank Jill Natron, who is our staff member that made it all possible. You might all think that I have conducted a very smooth symposium, but that's far from the truth. It was only with the help of Jill and the 6 student members of the Global Space Law Center Research Council. Kimana Bowen, Abby Jones, Rachel Harrington, Justin Daniel Dawson, Abby McCoy, And last but not least, Kaylin Fazia. So I thank you all. And I recommend that everyone keep your eye out for these rising stars. They're going to be very valuable for your organization in the future. So thank you again. And I wish you all a wonderful evening.